can have members turn on their cameras if they were on before, and we'll go ahead and get the meeting open back up. We will, because we were on break, go ahead and do a call to order with a roll call to establish a quorum again. So we will go into the second half of the combined nurse practitioner and nurse midwife advisory committee today. I will start.
This meeting is being recorded.
Thank you. I will start with a roll call vote with nurse practitioner advisory committee. Samantha Gambles-Farr. Can you, board moderator, check and see if Samantha is in the attendees? I'm not. See, she is in the attendees. Can you elevate her, please? Okay, Samantha, are you able to come off mute and let us know that you're here?
Thank you.
Awesome. Thank you. Dr. Ray.
Here.
Thank you. Dr. Espinosa. Let's see if she is in the attendees as well. She is not. Okay. Dr. E. Okay. Jan Griffin.
Present.
Oh, Dr. Espinosa just showed up. Hold on, let me get her.
Thank you, if you can get her up. Dr. Espinosa, are you able to come on audio and let us know that you're here? Thank you. I had communication that maybe Dr. Kevin Maxwell, MP, was going to be able to join, but I am not seeing him here or in the attendees. So we'll move on to Sally Pham. Sally, are you able to unmute and let us know if you're here? I will move on to Beth Schnelly if she is able to come off mute and let us know that you're here as well. Okay, we do have Sally and Betha both showing, but we have not received verbal confirmation yet that they are back in attendance. So I will recheck with them in a moment, and we'll move on to the Nurse Midwife Advisory Committee. Mary Phillips.
Here.
Thank you. Jenna Shaw Bautista.
Yep, I'm here.
Thank you. Dr. Byrne. Rebecca DeSantis. Rebecca, are you able to come off mute?
Yes, my daughter may have something to say.
Oh, no, that's okay. we were able to get that documented, so you're good. Thank you. Ruth Milkey.
Here.
And Hillary Reyes.
Here.
Thank you. I saw Sally pop on.
Yes.
Sally, are you able to give us a verbal?
Yes.
Thank you. And Betha, are you present? Wonderful. We have a quorum established for both the Nurse Practitioner Advisory Committee as well as the Nurse Midwife Advisory Committee. Thank you, guys. Okay, is Shannon here and available? I'm going to check her audio.
I am here.
Thank you. And Board Legal Counsel, Reza Pejuvesh. Are you here and audible?
Audible, I hope.
Wonderful, you are. Yes, we can hear it. Thank you so much. I will turn this over to Shannon, and we will continue at the second half of the combined Nurse Practitioner and Nurse Midwife Advisory Committees for today. Thank you.
Okay, so we are going to go through, this is the recommended guidelines for disciplinary orders and conditions of probation. And we call them disciplinary guidelines for short. just so you're aware, when we talk about disciplinary guidelines, this is the document that we are speaking of. And so we're going to go through this. And, Mark, I don't know, it may be easier if I share my screen so I can scroll through instead of having you try to scroll through and stay with me on it.
And controls that.
Okay.
There you go. Oh,
I will
almost.
go. Okay. And there we go. There we go. Okay. So we're going to go through this. Yeah.
Really quick, I want to make sure that all of the members that are operating in the WebEx environment, underneath the camera views of the individual panelists above, there's a negative and a positive sign. Mine right now says 89%. You can increase the size on your screen by zooming in or zooming out, and you'll be able to better see Shannon's presentation. So please go ahead.
I can also enlarge a little if you'd like as well. I have it down to 66% on my screen, so just let me know, and I can make it slightly larger.
Yeah, they should be able to control the viewing and stuff with the zooming in and zooming out on their own screen.
Okay.
So I could put you up right now on my screen. I could blow you up to like 179.
Oh, don't do that. You don't want me blown up to 179.
I can see your pores. No, I'm joking.
Okay.
Thank you, guys. Okay, well, long as you guys are able to see the disciplinary guidelines, Shannon will continue.
Okay, so this is the disciplinary guidelines. Table of contents. We're just going to kind of scroll through that really quick. Introduction. And I think I'm going to have to make it bigger for myself. I'm a little blind. So this is just going through the kind of the reason for the guidelines. Talks right here about how the board considers the totality, which we talked about earlier, of all the facts and circumstances of each individual case. The board requests that the administrative law judge clearly delineate the factual basis for his or her decision. So again, as we talked about earlier, the administrative law judges also use this document to apply the appropriate discipline to each violation in each individual case. So basically, that's kind of what this is saying here. Kind of trying to get to the meat of this. Factors to be considered. So in determining whether a revocation, suspension, probation is imposed in any given case, these are the factors that we take into consideration when looking at a case. So the nature and the severity of the act, offenses, the crime, the actual or potential harm to the public, the actual or potential harm to any patient, for any prior discipline record, and we keep record of all that. Prior discipline record, we may have cases that we have a pattern of behavior. So we look at those prior records for that. The number and or variety of current violations. For example, yesterday I just had a case where we have pending 6 actual complaints on an individual nurse. And so that is taken into consideration. Mitigation evidence. Normally we don't receive mitigation evidence until after we have filed an accusation. They then start submitting letters of recommendation, employment reviews, things like that. So we do take into consideration the mitigation evidence, any rehabilitation evidence. So that's normally on our substance abusing nurses, but also rehabilitation in the form of continuing education, should it be a patient care issue. In a case of the criminal conviction, we look to see if they're compliant with their court orders, their criminal court orders. And we look at their overall criminal record. It may be their second or third DUI. We take that into account. The time passed since the act or offenses. So for instance, if we have a DUI today and their previous DUI was 20 years ago, all of those are taken into consideration. And then any evidence of expungement proceedings pursuant to 1203.4, which 1203.4 has changed slightly. It does not allow us to, any case on applicants, any case that has been expunged pursuant to or dismissed pursuant to 1203.4. The board is not allowed now to take that into consideration when determining whether to deny or license the individual. Okay, so these are the violations and recommended actions. So this top portion, basically it's saying that we can take disciplinary actions. The following are all the code sections that pertain. These are all of our causes for discipline. And then it also says that it's dependent upon the nature of the offense. Again, before we went into the conditions of probation, the standard are 1 through 13, which we'll see here in a bit through this document. And then there's the optional conditions, which are 14 through 20, including an actual suspension of licensure. We also do this last sentence down here. If there is a patient death, we do include a condition 19, which is therapy or counseling in our decision. So it may be standard conditions 1 through 13, and then we'll add the condition of therapy or counseling should there have been a death related to that patient care issue or violation. So these are all out of the Nursing Practice Act. These are the Business and Professions Code that are our causes for disciplinary action. So 2761A1 is your unprofessional conduct, which includes your incompetence or gross negligence. So you have two sections here. The first one, incompetence or gross negligence, is the standard. The recommended discipline is revocation. The minimum discipline is revocation stayed with 3 years probation. And the minimum conditions would be the 1 through 13, the standard conditions as appropriate, and then 19 if there's a patient death. Now, should the incompetence or gross negligence, so if they direct another or personally falsify or make grossly incorrect, grossly inconsistent, or unintelligible entries in any hospital, patient, or other record not pertaining to controlled substances, there's a different set of recommended disciplinary action. The minimum would be revocation stayed with 3 years probation, and the minimum would be 1 through 13, probation 1 through 13 as appropriate for the conditions of that. So there's not a maximum here. There's not a recommended, just the minimum. So based on this is the minimum that we would pursue as far as a disciplinary action. 2761A2, practicing medicine without a license. Minimum discipline is revocation stayed with 3 years probation. The minimum condition is 1 through 13, or as appropriate.
Shannon, real quick, that practicing medicine without a license, would that entail a person serving as like a 103 or a 104 NP, and there's still a nurse practitioner that is supposed to be working under standardized procedures, so that they're working without standardized procedures? Is that what an example of that would be?
Yes, that could fall under that. Practicing medicine without a license would be prescribing when you don't have prescription authority. It would be anything that a physician would do that a nurse could not do without having an oversight physician or standardized procedures.
Thank you.
Mm-hmm. Okay, so 2761A3, fraudulent advertising. So if they're advertising themselves, I don't really come across the fraudulent advertising very much. When I do come across fraudulent anything on the internet, it's usually using RN inappropriately, but it doesn't normally fall under this fraudulent advertising. And I can't really, off the top of my head, think maybe for a business that's not a business per se, and as you all may be aware, an RN cannot be the sole owner or the majority owner of a business. They need to be 49% or less owner of a business. So maybe
medical corporation, right, is 51 physician, 49 RN, but the nursing corporation is 51% nursing and 49% other provider. And so that would be that. But another fraudulent advertising is like if they have dual licensure, a massage therapist saying that they're working under their RN license. Would that be potentially?
You know, I don't know because we haven't really used this code section. I can't recall it coming up. Normally, when we have cases like that, they're all falling under 2761A1. Reza, I don't know if you could think of, or if you've seen this at all in any of our cases, because I can't think of any fraudulent advertising where we've used 2761A3.
I don't have any actual cases that I can recall.
Yeah.
Trying to think of examples.
Well, maybe while you think of it, yeah, we'll move on. And if you think of an example, we can always throw this one back out.
More people starting their own businesses and such. I end up seeing that more often, maybe something on their website that they're claiming to be able to do or something to that effect.
I have a question.
Yes.
If you had a complaint
Hey, Jan, we're not able to hear you. Are you able to move closer to your laptop or?
I'm not sure what the problem is. Can you hear me now?
It's a better.
All right. If you have a nurse practitioner that has had a complaint against them for a practice issue, and they are holding themselves out as a 104, that's not the complaint, but they're holding themselves out as a 104. As a part of your investigation, will you be making sure that they are qualified and have completed all of that?
Part of the investigation for any nurse practicing, if they're advanced practice or if we always make sure that one, they've obtained their licensure, their certification adequately. They meet the criteria for education for that certification. We obtain all the records with that as well, especially if that's in question that they are practicing outside of the scope of what they're allowed to do.
Okay, and my real question was not. Well, my question was, they're practicing outside of it, but that's not what the complaint is about. And you've answered my question, so thank you.
Yeah, anytime that we come across new information that violates any part of our Nurse Practice Act in the investigation, that would be an additional charge that would be brought forward. And so right now, anybody practicing as a 104 would be subject to discipline because the 104 status is not even released and able to be granted until 26 right now. So anybody that would be operating independently as a 104 NP right now would be subject to discipline.
I have a one comment. May I comment?
Yes.
This is Dr. Espinosa. I think this is going to come into more play as we go on, just like Jan brought up. Somebody saying they're a 10, even a 10, practicing as a 103 or saying advertised as a 103 and actually being not quite there themselves, or even a 104. But also the advertisement of suggestive, if not letting the public know that they are a different type of nurse, not a physician. So I think that not advertising that as being, if people assume that they're physicians and practicing in a clinic alone, there may be some assumptions. And if that person is not advertising, there's a assumed advertisement that he or she may be a physician. So I think maybe that will become more evident as we're no longer, when nurse practitioners are practicing independently.
Yeah, I think with the recent media attention on that one and a nurse practitioner being disciplined in another state for referring to themselves as doctor without qualifying that they're not a doctor of medicine, but they're a doctorately prepared nurse practitioner, we might see that. But ultimately it comes down at this point is if you're saying that you're a medical physician, then and you're not, it would still be practicing medicine without a license. That would be the biggest thing and would definitely gain additional discipline because of that.
Yes. Okay. So moving on. So 2761A4, this is the one I had touched on earlier. This is the code section that gives us the authority to take action on any other state disciplinary action or any other license. So for instance, we have EMTs that get disciplined. They're under a healthcare license. This code section gives us that authority to take action against those cases, regardless of what the discipline was for. But again, we take everything in totality. So if it's less severe, it may not end up in formal discipline. But if it does end up in formal discipline, these are the recommended disciplinary actions. So it's recommended that we have revocation or revocation stayed with a 3-year probationary term. The minimum conditions that they are suggesting would be conditions 1 through 13 and as appropriate. So again, if it was another board action, maybe there was a death involved, we might include 19 as well for the counseling or therapy. So this is the code section that gives us the authority, and most states have a code section that gives them the authority as well. Most states will take action based on another state's action, regardless of what that violation was. 2761A is your general unprofessional kind of conduct. These are all the other actions that constitute unprofessional conduct, like failure to report, any client abuse falls under this as well. So the recommended discipline would be revocation. The minimum discipline would be revocation stayed with 3 years probation. So the conditions that would apply would be condition 1 through 13 for this particular action. Below that are some other items. So for instance, holding them oneself out as any of the following without meeting the BRN standards. So this may be where your question kind of fell into here. If they're holding themselves out as a nurse practitioner, a nurse anesthetist. So any of our advanced practice certifications would fall under this. And that would also be under the 2761A and would be the disciplinary action here is what would be applied to those. With the revocation as recommended and the minimum discipline being probation. Actually, sorry, for these, they took out the revocation. So holding them out, other than that, revocation is not listed. It's just the revocation stayed with 3 years probation. But the same applied conditions for this one. Procuring a certificate by fraud, misinterpretation, or mistake, which we are coming across lately. So that the minimum is discipline, is revocation. There is no other option here. If you have obtained your license or certificate by fraud or misinterpretation or by mistake, we're revoking that certification or license.
And just for clarification, that would be utilized right now in the new nurse practitioner process. If they attested that they completed their hours, their transition to practice through this physician oversight, and that physician says, no, that did not occur, that could be looked at in that setting. Or if the physician then says, yes, it did occur, the nurse practitioner said, yes, it did occur, and then we get a complaint later saying, no, it did not. That would be procuring a certificate by fraud, misrepresentation, or mistake, and not necessarily mistake at that point.
Correct. For example, on this one, I have a current case that I just got last week. I was notified by a local police department detective. He was notified by the physician that supposedly supplied logs for this RN to obtain their NP, and that physician never submitted any such logs. So the local police department is going after them criminally, and we are prosecuting them administratively. That would fall under this. 2761C, the involvement of in the procurement or assisting in a criminal abortion. I haven't used this one. I don't recall using this one in my 15 years with the board. But this is minimum discipline would be revocation with 3 years probation. And the conditions would be 1 through 13. You'll notice it also says as appropriate. So of course it gives us the flexibility on all of these. It says as appropriate, gives us the flexibility to allow us to apply conditions that maybe are outside of the 1 through 13, but gives us that flexibility to do so if needed. And I have to say too, when these conditions, for every case that goes to the board for vote, and it's outside, the attorney general, the deputy attorney general that's assigned to the case will write a recommendation to adopt letter. In that recommendation to adopt letter, they will give their rationale for why the conditions of probation or the disciplinary action in itself was determined and the conditions of probation. And if it lies outside of what the recommended guidelines state, they give the rationale as to why. Those are not public documents. Those are only for board viewing, but that does occur when it is outside of these guidelines. So the board can make a very educational or educated vote when they're reviewing the case. 2761D, violating or abetting violation of any section of the Nursing Practice Act. So minimum discipline. Again, probation, 3-year probation with minimum conditions 1 through 13 are as appropriate. Furnishing false information, 2761E. So there's 2 different ways. If they're applying for licensure, the minimum discipline would be the denial of that or the revocation of the license. In applying for their renewal of license, the minimum discipline is going to be a revocation stayed with a 3-year probationary term. Normally, let's see, it says that if the false information pertained to continuing education, then the license should be suspended until evidence of 30 hours of proved continuing education is provided. The suspension is followed by 3 years probation. Some of our CE cases, a lot of those go to citation. When we do our CE audits, if those come up and they can't provide, we do issue citations for some of those. They're the lower level cases that wouldn't necessarily warrant formal discipline. But the minimum conditions, if it does, is 1 through 13 or as appropriate. 2761F is our conviction condition. So it's our conviction code section. So any conviction of a felony or offense substantially related to the qualifications function. So a DUI has been determined to be substantially related to the practice of nursing. Therefore, that is why we discipline DUI cases. And this is the code section that gives us that authority to do so. It also includes, conviction for just about anything you can think of. All of the PC-23 type cases, the child abuse, murder, rape, assault. We have our lower level battery, theft crimes. We also have some code sections in 2762 when you're talking about convictions of controlled substances. There's code section for possession, for use, and so on. So there's some additional code sections, and I think they're in here that I'll go through in a minute. But if they do have a conviction, again, we take into consideration the totality of the convictions. If there are multiple convictions, for instance, a DUI is not a DUI is not a DUI. So if you have a DUI and the DUI, let's say it's a 0.8, there's no other egregious circumstances surrounding that arrest. That case is different than a DUI with a collision. They had their child in the car, scrubs on, and they were on their way home from work, just picked up their child from daycare. That is very different than the 0.08, no egregious circumstances. We have cases where they threaten the officer, don't ever come in my ER. So we have to take, with 2761F, we really take this into consideration, all of the underlying conduct at time of arrest. So the arrest reports are very, very important in these cases. The recommended discipline is revocation. And when we go through the mitigation, you'll see we do rely heavily on mitigation. We also rely heavily on if criminal court probation was ordered and kind of the things surrounding that as well. So we take those into consideration. A lot of our single DUI, low-level BACs, no aggravation at time of arrest, they will end up in a citation. But once we have multiples, that's when you get into it's an automatic disciplinary action. 2761G, impersonating an applicant in an examination, revocation. There's no other option other than revocation for us as the recommended discipline. 2761H, impersonating another licensed practitioner or allowing another person to use your license. Again, minimum discipline is revocation. That is the only recommendation in that particular case. 2761I, assisting in the violation of any of the provisions of Article 12 of the Medical Practice Act. And I don't really use that one. So Reza, I don't know if you're familiar with this one at all. If you want to chime in.
What specifically that is in the Medical Practice Act?
A lot of these, when you look up the 2761 section and all the subsections for the causes for discipline, there's a majority of them that are not really used. The majority of our cases all fall under the 2761A, unprofessional conduct, A1, with the incompetence, negligence, gross negligence.
And then just a FYI, Shannon and Reza, I did see that Heather Hoganson, our DCA's regulatory attorney, was in our attendees, and I had her promoted to a panelist so that she can kind of offer any insight, ask any questions, especially when we start to get recommendations for potential language change, since she will help to author that. I did elevate her. Heather, are you able to test your mic and make sure that it's usable in case you need to blurt out anything or get our attention?
Sure. Hello.
Perfect. Thank you, Heather.
Why Reza's looking for that. The next one is going to be of interest to you, especially when
real quick before you move on. So the one at the top of the page on the screen, a violation of any provision of Article 12. Article 12 is medical board's enforcement article within their Practice Act. So it's kind of the equivalent of Article 3, I guess, of the Nursing Practice Act, more or less. So it's kind of a general violation of something in the Medical Board's Practice Act.
Okay, so assisting in any violation of pretty much the Medical Practice Act would fall under the 2761I as an RN.
Would those cases be the ones where like a physician or surgeon does something? I'm trying to think of like the most recent kind of media one was down in San Diego, a surgery center, and a patient passed away. And it was a medical doctor and an RN that was involved in that, and they were both disciplined. Is that where that would kind of come up potentially, or am I just completely off in left field?
Well, it says the assisting in the violation of any of the provisions of that Medical Practice Act. So it would be a nurse assisting someone who is actually making the violation. I don't know, assisting a physician in I would assume any of the violations within the Medical Practice Act.
So Article 12 of the Medical Practice Act, it's section, it says commencing in disciplinary guidelines, it says commencing with section 2221. The article technically starts at 2220, but regardless, it goes all the way through 2319. So there's a lot in that article. So the types of violations that a nurse might commit that would fit within this particular violation could be pretty varied. Just as a random example, sorry, I had something and I scrolled away from it. Well, there's a whole bunch of things in that article that say it is unprofessional conduct for a physician to do this. So a nurse aiding and abetting in that conduct by a physician would be guilty of a violation of 2761I. Again, the types of violations there vary pretty widely.
Yeah, I would think our nurse would actually be disciplined under 2761A. And if they had the 2761I, we'd also probably have the 2761A as well, the unprofessional conduct. But again, I've not seen this code section used in one of our causes for discipline. It's usually just the 2761A, the unprofessional conduct. The next one is going to be of particular interest because this is the one holding oneself out as a nurse practitioner without meeting the BRN standards. So I could see this code section getting used more frequently moving forward. If someone is holding themselves out as a nurse practitioner under the wrong code, this may apply. The minimum discipline would be a 3-year probation with the minimum conditions of 1 through 13. 2761K, failing to protect patients by failing to follow infection control guidelines. I do believe was a couple cases during COVID where we may have used this code section. The minimum discipline on this is a revocation with 3 years probation, stayed with 3 years probation, and the conditions 1 through 13. And that is with no evidence of potential harm or actual harm to the patient. So if there is potential harm or there is harm evidence to the patient, then our minimum discipline is going to be revocation. 2762A, this is where I was talking about the substance abuse, possession. These are the code sections here. So 2762A is the legal obtaining, possessing, or administering of narcotics or dangerous drugs to self or others. We do use this in a lot of our diverting cases where they're diverting narcotics from this facility. So one, it would be if they're selling drugs for personal gain, the minimum discipline here would be revocation. 2, in cases of first-time offenses with documents evidence of ongoing rehabilitation, so they've supplied some mitigation of rehabilitation, we may issue a revocation stayed with a 3-year probation term with conditions, and now you'll see them change 1 through 19. So not only are we doing the standard 1 through 13, we are including the optional conditions for substance abuse of 14 through 19 without 20, which is the suspension. So on some of these cases, we will add that condition number 20, if you remember, that was the suspension of license. If we are not sure they are safe to practice, but we think that probation may be appropriate, we'll add condition 20 until we have their mental and physical exams done to ensure they're safe to practice. 2762 is the use of narcotics or alcohol to the extent that it's dangerous to self or others. You'll see this in a lot of the DUI pleadings. The recommended discipline is revocation. If it's a first-time offense, with evidenced rehabilitation. Again, if they supply some mitigation, we may consider revocation of stayed with a 3-year probation term. Again, we're looking at conditions of probation 1 through 19. So the standard with the optional chemical dependency conditions. And again, the condition number 20 of the suspension may apply. So we can ensure that we have clinical assessments done to ensure they're safe. 2762 is when they've actually had a conviction, criminal offense involving prescription consumption, self-administration of narcotics or alcohol, or the possession of or falsification of a record pertaining to narcotics or dangerous drugs. So in the cases where the respondent was under the influence, withheld or substituted drugs on the job. So for instance, if they did not medicate their patient and they took the drugs themselves, the minimum discipline would be revocation. In cases of first-time offenses with documented evidence of ongoing rehabilitation, except in cases where the respondent withheld or substituted drugs on the job. So anytime that they are diverting and they are taking their patient's medications, that would always fall under the revocation. In other cases, it would be a minimum discipline of revocation stayed with a 3-year probation term with all of the conditions 1 through 19. And again, 20 may apply here as well. And then in cases where the conviction for the falsification of records, the conviction is for the falsification of records pertaining to controlled substances, the minimum is going to be a revocation stayed with 3-year probation, and the minimum conditions are 1 through 13. We do have falsification of records pertaining to controlled substances. For instance, we have a case, we investigate it, we can obtain records to show that they falsified documentation, but we can't prove that they actually took the narcotics or medications for personal use. Sometimes we will give them the conditions 1 through 13, but we will also give them conditions 14 and 19. I hope I'm saying those right. That's the physical and mental health exam, to rule them out of being a substance abusing RN. If we can rule them out that they are not substance abusing, then we will stick with the 1 through 13 conditions. And if they are found to be having a substance use disorder, mental health issue, we will include the additional conditions 14 through 19. And we call that a rule out condition that we're currently using. But we do use that in cases where we're very unsure. We know that there's a violation of records pertaining to controlled substances. We just can't prove the diversion piece for personal use.
Now, Shannon, would this also come into effect where with DEA license? Because the DEA license is specific for controlled substances. And if they were falsifying any documentation for their DEA number or anything, would that also go on here? Because that would be records pertaining to controlled substance, because that's what the DEA is specifically for.
It could, yes.
Thank you.
Yeah, the majority that we get are the cases that I just kind of gave the example of. The DEA side of it, we don't see very often. It's usually the diverting without proof that they're diverting for personal use. It's just medication administration documentation errors.
And then I know we get cures data as well. And then we're also starting to get some of the pharmacy data. Private pharmacies, et cetera, are reaching out to our board with information when they're refusing to allow continued prescribing or furnishing privileges at an individual pharmacy location because they have identified some issues as well. So we do get various reports that come into the board in different manners.
Yeah, and just to tag on to that, so for cures, if you're all familiar, a couple years back, well, I guess it's been a few years now, time flies, the physician was required to, when initially making a prescription, would have to now check cures. They have to register with cures. We also use cures in enforcement. So if we have an NPF or a nurse midwife furnishing, anyone who's furnishing that we have allegations of overprescribing, if we feel that they are being prescribed medications that maybe, say for instance, they were pulled over and pills were found in their car. It wasn't, alcohol necessarily, it was prescription medications. We run cures reports to determine if they are getting medications, how often they're getting medications, are they doctor shopping? So we use cures as well in enforcement as a tool to guide us as to how we need to conduct our investigation. And then 2762 is the commitment or confinement by a court of competent jurisdiction. So if they are convicted by the criminal courts for intemperate use or addiction to narcotics, 2762D would apply. The minimum discipline would be a revocation, stayed with a 3-year probation term with conditions 1 through 19. Anytime you see the 1 through 19 and it's related to narcotics, alcohol abuse, 20 is always an option for us. And that is public safety number 1. We want to ensure that that nurse is safe to practice, and we have to, go through certain things just to ensure that. And so if we're on the fence not knowing that this nurse is safe to practice, we are going to impose condition 20, which is a suspension until we can get those assessments done. We are not going to put the public at risk. 2762E, falsifying or making grossly incorrect, grossly inconsistent, or unintelligible entries into any hospital patient record. This is a lot of the diverting, when we can't prove that they're actually diverting and we have the documentation, medication administration errors, the issues with the documentation, it would fall under this. And the minimum discipline would be a revocation, stayed with a 3-year probation term. Minimum conditions 1 through 13. But again, as I said before, we would add on condition 14 and condition 19 to have the mental and physical assessments done. We want to make sure that they were not diverting for personal use, and we want to make sure that they're safe to practice. Because normally when you have this issue of falsifying or making incorrect entries into medical records and it is involving controlled substances, more times than not, there's a possible diverting issue that you have there. So again, the minimum conditions would be 1 through 13. We would tag on the mental, physical to ensure safety. Now you see for repeated and similar acts, they're recommending or minimum conditions of 1 through 19. If it was repeated acts, we may possibly especially if it's in regards to controlled substances, I think we'd probably dig a little deeper and ask for a little bit more mitigation during this if we have repeated acts, because now you have a pattern of behavior. You see this a lot with nurses who were diverting in a hospital. The hospital, and this is quite a bit of a problem. The facility does not do a for-cause drug screen on the nurse. They terminate their employment. The nurse then moves on to the hospital down the street, and the process continues. So, we may have allegations that we can't prove or substantiate, but now we have, 2 or 3 complaints that have been filed. And if the facilities would do a for-cause drug screen, it would help us a little bit. Also, on the cases when we were talking about the possible diverting narcotics or stealing, if facilities would file a police report, that would also be helpful for us. Because a lot of times some of that evidence is very hard to obtain later when the situation first occurs. It's much easier to get that evidence. And when the facilities help us out in obtaining those drug screens or urine analysis, or they file police reports, that is very helpful for the board. Okay, so 2836.3. Again, it's the incompetence, gross negligence by a nurse practitioner in performing functions related to furnishing drugs or devices. So again, this would apply to a nurse practitioner when furnishing and there's a level of or a finding of incompetence or gross negligence, this would pertain to that. And the recommended discipline would be revocation. The minimum discipline would be revocation with a 3-year probationary term with the minimum conditions of 1 through 13. So just the standard.
And then Shannon, I'm going to interrupt really quick just for our attendees that are not nurses, public members, etc. Furnishing in our language is prescribing. And so that is the same thing that, but we use a furnishing license in California to show that these advanced practice RNs have the ability to, write prescriptions, order drugs, etc.
These are just some of the additional business and profession code statutes. I'm not going to go through each and every one of them. Photographing, photostating, duplicating, in any other way, reproducing any license. So if someone falsifies a license, obviously the recommended discipline is going to be revocation. The minimum is going to be probation, 3-year probation with the conditions of 1 through 13. Any person that's licensed under provision 1, 2, 3 of this code is guilty of a misdemeanor to the disciplinary provisions of the code applicable who conspire with persons not so licensed to violate any portion of this code. So basically kind of like the medical board one. So if anyone assists or conspires to a person that's not licensed to and that violate any portion of this code, that they would fall under this section. So A, they allow their license to be used by such a person. So if I gave my license to Lori to use any acts as his or her agent or partner, the recommended discipline is going to be revocation. Minimum discipline is going to be revocation with a 3-year probation term, stayed with a 3-year probation term with the minimum conditions of 1 through 13. Refusal to perform license activity. We've had this, I don't know if we've actually used this code section, but we have had this circumstance. So aiding or inciting refusal of performance by another licensee, or discrimination or restriction in performance due to race, color, sex, religion, ancestry, physical handicap, marital status, or national origin. We have had refusal to treat patients. Recommended discipline would be revocation. The minimum discipline would be revocation, stayed with a 3-year probation term with conditions 1 through 13. This is an applicant, so this would be a denial. And these are the acts that are disqualifying. So a conviction of a crime, which again, 1203.4 has now eliminated the board. We cannot take into consideration a single conviction for denial. So we can't take that into account. Also, if it's been, unless it's an egregious act, if it's been more than 7 years, we also cannot take that into consideration. If it's been dismissed pursuant to 1203.4. And then any act involving dishonesty, fraud, deceit, any act which if done by a licensee of the business professions in question would be grounds for suspension or revocation. So those are all of the reasons for denial of licensure, an application for licensure. This is also for application for licensure, and that is just giving a false statement, and that would be denial of licensure. Let's see. Let me go down to here. So subversion of licensing examinations, that would be denial of licensure. So all of these pertain to the application of licensure. Securing license by fraud, again, we have that up top as well. It would either be denial of licensure, suspension, or revocation, depending on the situation. Sexual abuse misconduct, it's going to be revocation. So knowingly presenting or causing to be presented any false or fraudulent claim. This is going to be revocation. The minimum is going to be a revocation stayed with 3-year probation with conditions 1 through 13. A lot of these fall under unprofessional conduct, and normally for a lot of these, we just use the unprofessional conduct code. These are kind of a secondary.
Would that one there more specifically be used for billing practices and issues around that? Those are the ones that like Dr. Ray was referring to earlier.
Yes.
Okay.
And this is kind of specifying more so insurance for contract of insurance. I don't know, depending on what the billing is like, whether it would fall under that or not. It would just depend on the circumstance. Okay, so you have again, these are these subsections, everything in 2761A is all your unprofessional conduct. Those are usually all of the codes we use when we're preparing, or when the AG is preparing a pleading, and those are your causes for discipline. These are kind of secondary, except for when you get down here to 820. 820, if you remember in the presentation, that was our authority to compel a nurse to a physical or mental examination. So if they are unable to practice safely because of the ability is impaired due to either mental or physical affecting competency, we will actually issue the statement to compel them to the eval. And that's when we get back. So with the 820, once we have them, if they comply with the 820 and they are found safe to practice, we close it. If they comply with the 820 and they're found not safe to practice, we file an accusation. If they do not comply with the 820, we file the accusation based on noncompliance.
Thank you, Shannon. So we're an hour in. We have 2 hours remaining of the meeting here. The remaining sections of our disciplinary guidelines kind of talk about a lot of what Shannon's already kind of presented in the first part of the morning, where she kind of talks about the enforcement process and the different criteria and stuff throughout that, and how we take that into consideration. So at this point, I know that there are members here that kind of have reviewed this, and now thank you, Dr. Ray, for bringing up the medical disciplinary guidelines, and I'm hoping that people had a chance to kind of at least look at that a little bit during the lunch hour, and just have a discussion. Where do you guys think that we need to have some focus and maybe update more specifically? As you guys can tell already, we do have sections that address the advanced practice RN role. We do have sections that do address record keeping and billing practices and prescribing, although not to the kind of granular effect that I think that we're probably aiming for. But I want to kind of make sure that we facilitate this next couple hours of conversation here between both NMAC and NPAC. Both have physician members, both have public members, and both have advanced practice RNs as part of the committees. The one thing that I really want to point out is that independent practice has occurred in the advanced practice role underneath the BRN's jurisdiction that has been using the disciplinary guidelines. Our nurse midwives have had an independent practice since, at least going on a couple years. Where when they had SB 1237 passed, it removed the requirements for standardized procedures, and they have been operating in that independent manner for the last few years. We know that the nurse practitioners are gaining that ability just as of a week or so ago now, where they can start to function as a 103 NP. Again, the 104 NP is not open and available for use until looking at aiming for January of 2026, maybe sooner. But that is really kind of where we're living at right there, because the 3 years is required to operate in a 103 in good standing in order to become a 104, with, of course, the exception for some of the clinical hours being counted towards those that are doctorally prepared. So that is up there too. But then also to understand that our nurse anesthetists have had an independent practice for many, many years. So what we need to look at is there areas that we need to specifically address? Are we okay with the way that our discipline processes have been going to date when we're looking at independent practice? Because we do have at least 2 of our advanced practice RN that are currently operating right now without standardized procedures. And then just really kind of pointing out on the NP practice is, I know people start talking about that it's an expanded scope of practice, Our scope of practice has remained the same. The supervision requirement is now what is removed. So when you look at the definition of the 103 NP, they are able to function in a group setting, practicing with at least one physician surgeon, and that they can do this without standardized procedures, and must be within the education and experience that is in alignment with their national certification. So if they have a national certification as psychiatric mental health nurse practitioner, that is their scope of practice, is only what is their education and preparation, their clinical practice in psychiatric mental health, and their national certification for psychiatric mental health. They are not allowed to have an independent practice or a practice without standardized procedures in any of the other specialty areas, unless, again, they do another transition to practice, they have another national certification that's population focus, and they have another education preparation, like a post-grad prep for being able to sit for that national certification and getting licensed in that manner. So it is a very focused scope of practice that allows them to operate without standardized procedures, again, as the 103 in a group setting, as a 104 in their independent practice. Also wanted to make sure that people understood that nurses have had nursing corporations, they've had their own practice set up in the past. Their practice now is not different or new, essentially, because of this law. What it does allow for is, again, not to have the overseeing physician with them on that. And that would only be for the 104. It is still, because AB 890, when that was wrote and passed, has definitions of healthcare facilities or group settings that are specifically written into that law that does not encompass that independent practice setting as a 103. It's a group setting. So knowing those kind of things, I want to open it up for discussion. We're here to ask questions. We're here to bounce off ideas. And if Heather is ready, she can even jot some notes down for potential regulatory changes that might come out of this. I do ask to try to come to consensus for both the nurse practitioner and the nurse midwife, if at all possible, because we are looking at this in a more general form versus a title specific form, because it is all kind of practice related and maybe substance abuse or mental health related. So open it up to you guys.
Lori, can I chime in? This is Edward.
Absolutely.
Sorry, and I certainly don't want to dominate the conversation. I had compared the documents that you all sent to us earlier, and just a couple of things jumped out at me. I would sort of categorize into 2 parts. One is sort of like, how do you identify violations and what are violations of conduct? And then the second would be sort of the disciplinary component of this. And I already mentioned earlier some of my thoughts on that, but just to better articulate that, I certainly think that the way that the current regulations are portrayed, it applies very well to all existing categories, including 103s, except for maybe the 104s. And I think that's where I wanted to make a few comments. And certainly I think the way Shannon went over the existing regulations. That was helpful to me to sort of articulate what is already covered, at least under the violation section. So, I sort of divided these up into a few different categories that I sort of saw were not as well described compared to the way the medical board spells it out. And I realize this is not meant to be a carbon copy of the way the medical board issues their guidelines and disciplinary regulations. But things like, specifying some language about scope of practice, like if a practitioner is working outside their scope of practice, should there be a category that at least if the board is concerned that somebody is grossly working outside of their scope of practice, that is identified. Sure, this could fall under professionalism, but I think that's a little bit too much of a catch-all and very much up for interpretation.
Would that be maybe under the practicing medicine without a license? Because that would be the scope of practice they would be moving into. Or am I misunderstanding that?
Well, I'm just posing these as ideas right now. I don't know that we have the time to go into each one of these categories. I'm just going to propose these maybe 5 categories that at some point we could address or break down. So there's that. There's prescribing practices, which I guess you're saying are already included in the regulatory language. Billing practices.
Yes, under the furnishing. That would be our prescribing currently. There is talk about in the future that furnishing will be moved and they'll be able to prescribe essentially under their license. That would have to take a legislative move. And if that happens, we would then have to update the language here and remove furnishing and add prescribing or something to that.
Okay. There is a lot of language on the medical board website specifically about business practices, billing practices. One big one, I will say, I've reviewed cases for other medical boards, not in the state of California, but very often when nothing else can really be pinned down, but there's clearly something going on with a practitioner kind of going off the rails, it has to do with record keeping. And violations of proper record keeping are something that I think should be addressed separately. And what that means is, for example, it's one person's word against another. A patient says, oh, they never got my consent to do this procedure. And the doctor says, no, we went over informed consent, but it's not documented anywhere. So where does that fall under? Professionalism, whatever. But the point is, if you have sort of very specifically stated in your regulatory language that, poor record keeping is a violation of professionalism, and this is not up for interpretation, this is a requirement, I think that would be helpful to the BRN in the future if they have to discipline those kinds of situations. We could go into a whole diatribe about business practices and things like that. I don't want to spend too much time on that. At least from my viewpoint, that's probably covered elsewhere, under business and professions. But I'm just kind of laying out there. Then the second component of all this is the disciplinary actions, which is I think maybe where you might want to spend a little more time thinking about things like I mentioned earlier. There's no mention in any of this language about surrendering their DEA license if they violate prescribing practices or illegal substance use or assisting others, prescribing to drug addicts, things like that. There's a lot of very specific language on the medical board website about that, which could be helpful. But I think there ought to be language about that under disciplinary actions. Prohibition of certain practices. It should be under the power of the BRN to limit 104 practitioners from performing certain procedures if they feel it's outside of scope of practice, but it's not otherwise delineated. This is something that medical boards do all the time. They say Dr. X is not trained in doing that procedure, but they keep doing it and they keep having complications. We're going to tell them they can't do it or they may be punished. It's not out of malfeasance. It's just out of, outside of their experience, outside of their skill set. So again, I'm just putting this out there in general ideas of things that
definitely
they want to adopt, under disciplinary actions. Another thing is the use of chaperones. So if you're concerned that a practitioner is engaged in sexual misconduct, there is no language in here that really identifies a 104 practitioner's solo practice. If they are working by themselves, all this language about your employer has to do this, your employer has to do that doesn't make any sense because it's an independent practitioner. So there should be language about things like supervision, chaperones, prohibition of supervising other 103 and 104 practitioners. Again, that's something that right now there's language about supervising RNs, which I know could apply to a lot of different categories, but I'm just saying, if you want to be a little more specific, those are some things I would look at. And then lastly, the medical board also mandates for certain behavioral aberrations that maybe don't quite rise to the level of suspension of a license, requiring that they take certain courses on professionalism, ethics, prescribing practices, just general professionalism. I don't see any language in here on that, and that might be a good thing to empower the board to have some requirements that if they want to maintain their license and they've had some minor infractions, that they have to complete these types of courses. So those are my thoughts and ideas. I just want to put those out there. Thank you.
Yeah, I think those are all valid. Thank you for those. That was one of the discussions that we were having internally about the change to now our probation status. Our workplace approvals are specifically set up for a lesser independence, right? And so we have, RN supervision or another nurse anesthetist supervising another nurse anesthetist. When you have an independent practice, that's not necessarily available. And so some of the discussions that we've been kind of having is, a workplace monitor, very much in alignment with what the med board has when their medical doctors are put on some sort of probation as well, is they would have a monitor assigned to them as a practice monitor that would then go and work with them or observe them or be part of their reviewing of charts and documentation, et cetera. And that's something that our board does not have set up. One of the other discussions that kind of went around that is if these practitioners, midwives, nurse practitioners, et cetera, were to have any violations and have to be going into a probation kind of situation, would the part of the disciplinary guidelines be recommended that they work under standardized procedures, again, for the 3-year or 5-year probation? But then you also have to take that into consideration. Okay, what happens to that practice if it's set up as an independent practice? And so we don't want people to lose their complete livelihood. We do still have to make sure that patient protection is obviously our number one goal. So how do we work with that? And so those are some of the discussions and stuff that I know that we've had. I love that you're thinking in a lot of the same manners there. Anybody else have any kind of thought processes for any of these updates, anything that you guys have seen that have stood out? Just further discussion on this. We do have Heather Hoganson on again. She is our regulatory attorney, so I'm sure she's taken notes. In the audience here, we also have our Chief of Legislation, Marissa Clark, that works closely with Heather on drafting language. And we do have our regulation guru as well, Roz, on the line here. So all of this conversation is being kind of monitored and looked at, and we will be taking this into consideration as we look at updating these guidelines. We do have a plan that our disciplinary guidelines, the regulatory language, we want to present it to our board by the November board meeting. We want updated language, whether it includes updates to, the specific independent practice of our advanced practice RNs or not. We will be updating our disciplinary guidelines. It is due. And so we will have language in front of our board with a goal of the November board meeting this year. So we're going to do everything in our power to meet that goal. It's not an official one. It's kind of my goal. But that is our aim.
I have a question or a comment. First of all, I wanted to ask the 103, you said, what fields are there's 2 103s right now that are out working now. Where are they working? Do they, what kind of facilities? Because it never was really clear in our regulatory, regulations.
Dr. Espinosa, I'll provide some clarification on that really quick. The group practice setting is not in our regulations, which is probably why you're not finding it there. It is in our statutory language, and there are multiple codes that it refers to where they define what a group practice setting is for our 103 NPs. And then just so you're aware, 103 NPs, any of the essentially 8 categories can be approved and working at this point. They can apply through the Breeze application that is up and online, and they're licensed here in California as a nurse practitioner. They've met the transition to practice requirements within the last 5 years. They've had a physician and surgeon say yes, that they've met those requirements as outlined in AB 890, and then their national certification. So family individual across the lifespan, adult gerontology, both primary care and acute care, neonatal, pediatric, both primary and acute care, women's health, gender related, and psychiatric mental health across the lifespan. Those are all of the categories of the 103 NP that could be out and practicing today in a group setting. How AB 890 describes a group setting is they talk about a clinic as defined in section 1200 of the Health and Safety Code, a health facility as defined in section 1250 of the Health and Safety Code, with some exceptions that are listed out there, a facility described in chapter 2.5 commencing with section 1440 of division 2 of the Health and Safety Code, a medical group practice including a medical professional corporation as defined in section 2406, and section is business professions, just so you're aware of that one because it doesn't specify health and safety. And then a home health agency as defined in the Business Professions Code, section 1727, section 1727 of the Health and Safety Code, and then a hospice facility. Those are the only group settings that a 103 NP can operate in. They cannot operate in any other group settings. Those were not defined in the statute that was put forth by the bill language. We did not further add to those group settings. We did not change any of those group settings or put any limitations onto those group settings when we wrote the regulatory language. So those are the only group settings that these 103 NPs can operate in. And again, those are, requirement is they have to work with one or more physicians or surgeons as part of those group settings. And so that is not a supervisory requirement, but that is a requirement that they practice with that physician and surgeon, that they are not independent. They just don't have to utilize standardized procedures.
So they can work with one physician.
Correct.
And that would be considered a medical group, correct?
If it meets the definition of the medical group practice defined in section 2406.
Right,
we have
right.
several people reaching out to us that says, I'm working with a telehealth company out of state. Can I do that? And no, they cannot, because that doesn't meet the medical corporation definition of section 2406 in our state. And so it has to meet these code sections that are outlined in AB 890 and now made permanent until any further change done through legislation of Business Professions Code 2837.103, and that is A 2D, I believe is how you would reference that, or A2, sorry, and that has all of the group settings. So they're very specific locations. It's not just carte blanche.
So that with that might be because I'm sure that there's probably room for interpretations for some of those settings. I mean, it sounds like it's very specific, but I'm wondering if that may be another area that we have to be looking at in terms of possible, violations.
Yes.
And leading that even that might be another section, and many of the sections that Dr. Ray brought up, that might be another area, because I think there's a lot of room for wider interpretation by the outside, and so, no one is going out there to visit the clinic, it's all by the word of the person signing that, yes, they practice, or they're going to be practiced. This is a 103 setting. The other thing you mentioned.
So just real quick, just to clarify that, Dr. Espinosa, again, the attester, which is a physician or surgeon, is the second person to corroborate or collaborate with the attestation that the nurse practitioner gives. It's not a single person. It is multiple people saying that, yes, this is what occurred. And it is put forth as under penalty of perjury. So, and we have several codes in here that if people lie about that this is definitely a problem for both the attester as well as the nurse practitioner saying, I did it. Both of them, both through the medical board or the osteo board, as well as our board, would be brought up on disciplinary charges. So it is definitely not something that is taken as with just a grain of salt. And if we get a complaint at all that this is not accurate, we will be doing an investigation. We will go out to those areas. We do in person versus as well as by phone. We do all kinds of interview processes to investigate this. The other thing is because we collaborate with other boards and bureaus, say a dentist or a veterinarian gets a complaint and they go out and investigate them and they find an RN working there or a nurse practitioner or anything, or a nurse midwife, God forbid, working in a veterinary office or anything like that pop up, they let us know that, hey, we went out there and this is what we saw. And so there's a lot of hands-on, there's a lot of eyes on, and we do get a lot of reports. And we do go out and investigate each one of those that are received. So I want to make sure that it's not just a simple, yes, I did this, like the penalty of perjury and having more than one person saying that, yes, this occurred is important to kind of take that into consideration with this. And then, yes, if they're not practicing in the area that they're supposed to be practicing, that is unprofessional conduct, and we can discipline them today with our current disciplinary guidelines. But if we want to add to those, we absolutely can consider that as well.
Yeah, well, that's why I'm just saying that it may be another area to be more specific. Now, I think I misheard you. The nurse anesthetist is falling under this 103, 104? Did I miss?
No, what I was trying to explain is that we have 4 advanced practice RN types underneath our board. And 3 of our advanced practice RN types have independent practice. It's only our clinical nurse specialist right now that does not have independent practice. So our nurse anesthetists have independent practice for years. Our nurse midwives have had independent practice for a couple years. And now the nurse practitioner, as of about a week ago, has the ability to move into a more independent practice. And so when we're looking at our disciplinary guidelines, the reason that I pointed that out is we've been using them for advanced practice RNs with independent practice already. We've been using them effectively for our nurse anesthetists and our nurse midwives. And so I want to make sure that the committees take that into consideration when they're moving to update them, so that they have an awareness that this is not the first time these guidelines have been used for independent practice and disciplinary actions around them.
So they're now, they have already been practicing without standardized procedures or right? For
Correct.
A while now.
Nurse anesthetists do not use standardized procedures. Okay. Nurse midwives have not used standardized procedures for at least 2 years. And our nurse practitioners are still using standardized procedures. However, if they choose to move towards a more independent practice to become a 103, which is what's available now, they can work without standardized procedures in a group setting. It will not be until 2026 that they can actually practice in an independent location without standardized procedures.
But the nurse anesthetist right now is able to practice without the procedures, but without supervision as well.
Yes, they do practice without supervision. They are referred to. And once that referral has been made, their scope of practice is considered independent.
Thank you.
You're welcome. Thank you.
I have a question, and I'm sure it's documented somewhere, but I don't see it in the recommendations for put here. Sorry about my son. But I'm just looking at the compliance with the board's probation program, and I'm just wondering where the standardization is, or is this a case-by-case basis and the probation is put forward by a... Where is the standardization of the probation?
I'll let Shannon kind of talk to that more, and I know that Reza will be able to kind of jump in as well. Every case is investigated individually, and all circumstances around that case is looked at individually. Then we have our subject matter experts that look at it from that specific kind of viewpoint. So if it's a nurse practitioner that has violated the Nurse Practice Act, it's that subject matter expert is going to be a nurse practitioner. If the nurse anesthetist has violated the Nurse Practice Act, the subject matter expert is going to be a nurse anesthetist. So it is people that are currently practicing in there that have that expert viewpoint to be able to opine on any of the cases that are in front of us. And they have to be current in practice as well. They cannot be removed from practice at all. Now, once they get that, it does go through the investigation process. And as Shannon was mentioning, is a lot of our, throughout the court systems, they look at our disciplinary guidelines, and that's where it becomes more standardized, where they will then take what has occurred, apply it to the disciplinary guidelines, and then the order or the stipulation is based on what our disciplinary guidelines recommend for what a person would be subject to for discipline. And then Shannon, Reza, if you guys want to add to that, jump right in, please.
Well, just the standardization comes from what I just went through, each of the different causes for discipline. It gives your recommended probationary terms. And those probationary terms, I kind of went through them earlier, but let me just scroll down on this document because it gives you all of the conditions and they're standard. 1 through 13 are your standard conditions. They're right here. And that language is exactly the same on every condition. And then here are your optional conditions that I talked about. If you go further down into the document right in here, this is where your conditions start. So this is all of your language and the standard conditions. All of this language remains the same in every single decision and order if probation is ordered. So we don't deviate from this language at all. These conditions are meant to be flexible, but at the same time, allow the board to monitor someone. For instance, so if you go down to section 6, so 6 through 9 are your employment. It's your functioning as a registered nurse, how they have to get approval for their employment, how they have to be monitored, what the level of supervision is that we would implement, whether it be maximum, moderate, or minimum, if they're in a home healthcare setting. So with nurse practitioners and some of the stuff that Dr. Ray was saying earlier, I can see some of these conditions of probation wanting the language in here to be more specific to a nurse practitioner or a nurse midwife. Because with the employment, and I can't remember which condition it is, I'm sorry, but they have to function as a registered nurse. But if they were in an advanced practice setting, so right here it says the board may require that advanced practice nurses engage in advanced practice nursing for a minimum of 24 hours per week for 6 consecutive months. So you could add language in here to be more specific, but to your question, these conditions, all of this language, this is standard language, and we do not deviate for the most part from this language. And this is what we use. This is what the attorney generals use when they're preparing these documents for us. And this is what the administrative law judges use when they're writing their proposed decision.
I figured it had to be somewhere, but couldn't find it, and I jumped ahead too far. The only follow-up question I might ask is, in this, and it's kind of small for me to see on my screen right now, I apologize. The determination of the violation of said, who determines there's a violation of the put
So
forward requirement?
So if it's a practice case, we provide the documentation in the investigation and all of the evidence that's needed. It goes to the Attorney General's office with the expert report. So we rely on our expert to review each allegation and determine whether or not there was a deviation from the standard of care. And then it goes to the Attorney General's office and they determine whether or not they can defend and substantiate that, and that is where the pleading comes from. So it's in concert with both the, we rely on the investigation, then we rely on the expert to determine from that investigation if there's a violation and, to what level was the deviation, and if there was gross negligence or if it was incompetence, where I, in the previous presentation, I kind of laid out those different scenarios, and that's what they use as that language to determine the level.
So I'm just trying to clarify a little bit. My question was more to violation of the probation. Who determines the severity of the violation of probation?
So violation of probation, the determination of severity. So any violation gets a violation notice regardless. Whether it be a missed call. So for instance, all of our probationers who are on the optional conditions, they have to call in every single morning to see if they have to test. We're all human. Some of them miss a test or miss a call. If they miss a call, it's a violation notice. We don't normally send them back to the Attorney General's office for that. It's very low level. Now, should they miss testing, they call in, find out I have to test today, and then they don't go in. A missed test to us is considered a positive test because it's a tactic to avoid in a lot of cases. So in that case, we kind of have to take that into consideration. Is this the first time? Is it the second time? So we have analysts that have to analyze these cases, and it goes up to upper management, and we take into consideration everything in totality, just like we would a normal case going for investigation. We do have two conditions where we don't violate them necessarily, but we do extend their probation. And that would be one, if they can't pay their cost recovery, or two, if they can't comply with the employment requirement of the 24 hours per week for 6 consecutive months. We can do a 1-year in-house extension. But everything they violate, we have to document that with a violation notice, regardless of what the violation is.
That answers it. Thank you. I appreciate that.
Questions or comments?
Can I take a moment? This is Reza. Just wanted to add something real quickly. So Shannon did a great job explaining kind of the how the disciplinary guidelines ensure this standardization of the probation terms, and tried to treat similar cases similarly. And she did say we generally don't deviate from them. I did want to make one clarification, though. The disciplinary guidelines are kind of the starting point, and generally, for the most part, kind of, I would say just from what I've kind of seen informally, probably the ending point. Generally, the level of discipline is pretty closely kind of matching what is dictated in the disciplinary guidelines, but it is a starting point, and there is authority to deviate from the disciplinary guidelines in situations where it's appropriate. So generally, like Shannon said, your disciplinary orders will all read exactly the same. The language of the first 13 conditions of probation will be nearly identical, etc. But occasionally you see a situation where an administrative law judge saw reason to deviate from the disciplinary guidelines. For example, sometimes you see it in like the term that's on the screen now, employment approval and reporting requirements. maybe the judge, due to some circumstances having to do with the violation, or maybe due to circumstances having to do with the licensee's current employment and their need to continue that employment, for whatever, reasons may come up that a judge might deviate. And so I mention that because in thinking about kind of the input that these committees can provide, as has been said, it can be to kind of tailor some of these terms of probation for specific cases that involve NPs or midwives. Also, just be aware that an ALJ may do that independently without being told, in the disciplinary guidelines. They might find a reason to write in an additional requirement or to modify a requirement or something. So there is some mechanism, of course, standardization and treating similar situations similarly is important and good, but for those situations that are maybe not constantly reoccurring, but do have to do with, say, NPs or midwives, there is already kind of a mechanism where the ALJ can kind of build something in that's kind of tailored to the type of violation or the facts of the case. And also, just to remind you all, this is kind of a separate point I just wanted to make, where this document fits in. So you got a lot of background today, a lot of information about the process. So just to remind you where this fits in, there will be at the very beginning a complaint filed. The board will do an investigation. If it finds cause for discipline, the board will file a public document called an accusation, starting the formal discipline process. If the licensee contests it, it will go to a hearing similar to a court trial. You can picture it more or less kind of similar. And then the judge presiding over that hearing will take testimony and accept evidence, and all of that will constitute the administrative record, which will serve as the basis for whatever decision that gets made. That's where this document comes in, is after that hearing takes place, the judge reviews the facts and the law and decides, okay, here's the outcome, here's where there was cause for discipline, and according to these guidelines, here is the recommended outcome for that type of violation. So the document may have other uses as well for informing the complainant in the first place and the public and all that, but its main usage is at that stage after the hearing where the administrative law judge is deciding what's the appropriate outcome based on the facts that were found at the hearing. Once the administrative law judge writes their decision, it'll go to the board, and the board will either ratify that decision or reject it and make a different decision. And there as well, the board is also considering these guidelines. So that was all I wanted to add. Hope that was helpful. And if you have any questions, please let me know. I think there was somebody else who I cut off, and I apologize for that.
That was me.
Samantha.
It's okay. Thank you, Reza, for that information. That did give some clarity. I wanted to speak to a couple of things that have just kind of been brought up. Specifically, the scope of practice that Dr. Ray spoke about. Maybe I'm misunderstanding the further need for definition of the scope of practice for 103 and 104 MPs. The only way that I could see that this could be implemented in currently what we have in statute is perhaps under 2761-A, where there's clear definition of violations under which sections, where nurse practitioners, certified midwives, and public health nurses are listed. I think that could be beneficial there as far as, because we have nurse practitioner, but that's the assumption that nurse practitioner is still practicing under standardized procedures. And so we would need to have language in there specifically speaking to nurse practitioner 103 and 104 NPs, so that they are represented. Yes.
Samantha, real quick. The nurse practitioner is the license type. And so a 103 and a 104 is a category or a modifier. So
Okay.
it would be exactly the same as if you were licensed as a nurse practitioner, but you're a family practice nurse practitioner, family across the lifespan, sorry. Or if you're a psychiatric mental health. Those are the categories of your nurse practitioner, but your certification is your nurse practitioner. So it would only be needing to have an additional scope kind of explained there if it was grossly different than everything else. And it's
Right.
my understanding is it's not. So the nurse practitioner, even though it just says nurse practitioner, we would then look at your license specific. What are your various categories, right? So
Right.
if you were a pediatric nurse practitioner by training, you were not a 103 or a 104. You are a pediatric nurse practitioner by training and you're utilizing standardized procedures. The only way that you would be able to work in a setting that's not a pediatric nurse practitioner, say you wanted to work in adult liver and GI, right? You
Right,
would have to do
right.
that based on competence, not based on your pediatric nurse practitioner. So
Yeah.
we would look at what your categories are, what your competencies are. And so it wouldn't necessarily change any of the process that we already have. If when we look everything up, we say, oh, okay, they're a 103 in family across the lifespan. But they're practicing as a women's health nurse practitioner. Well, that right there is problematic if you're doing it as a 103 because you're only put forward as a 103 in the family across the lifespan. Does that kind of make sense?
No,
So-
that completely makes sense to me, which
Okay.
is why I was questioning or asking about the scope of practice and where that would need to fit in currently, seeing that we have nurse practitioner clearly defined here. That was my question.
Okay. Yeah, all nursing scope of practice. So again, back to kind of what we talked about really early on in the meeting, the RN license is based on competency. And so if you are not competent to practice in any area, you can be disciplined. And that's where Shannon, I believe, had on one of the slides what is competence. And so that's what it always will come down no matter what, because your certification just says that you have the ability to work in those areas. That doesn't say you're competent. That competency is established typically through your employer, your independent practice, as things kind of morph and go to your 103 and 104 status. That's why the OPES did the national certification look to make sure that that kind of helped with the competence, et cetera. So hopefully that helps to provide some additional clarification there.
No, that makes complete sense to me. I was just a little confused. The second question that I had was regarding the prescribing and needing to, there was some mention and I wanted to respond right away because it's been a little while since he kind of discussed this, but understanding that we furnish currently and that language will likely change, may not change. If someone has disciplinary problems and they're either put on suspension or probation, like I don't know exactly what the model is, and perhaps Shannon can speak to this as far as notification. If they lose their license completely, I'm sure that there is some notification that they no longer have their license anymore and that their DEA is taken away, if that's correct. Hello, that was a question. You guys can hear me, right? Okay.
I don't know that I was able to hear you. Sorry, Sam. This is me. This is Lori. Sorry. If
Okay,
you can
that's,
repeat it if it was directed towards me, I did not hear the question, so I
Okay.
apologize.
no,
But I don't know if it was directed towards Reza or Shannon, or if anybody else was able to answer it. I'm sorry. I
So-
cut off on my end, and I was even having a hard time getting off mute to say anything.
Okay, sorry. Can you hear me now?
I can. Yes, I think it was probably just a glitch on my side. I apologize.
No worries. So I guess as far as the prescribing and the furnishing information, there was some questioning as to ensuring that DEA is notified, and I'm sure that this is already done, because this was a question that came up behind the scope of practice. There was like a list of 4 things that were mentioned, and prescribing was one of them. And you addressed the issue as far as how we currently furnish, and that may or may not be removed at some point, and it probably will be. But I'm sure that all that information is all tied together as it relates to our licensing and things like that. And if someone loses their license in the state of California, as far as not being able to practice, then I would imagine that there's some notification on some type of DEA front as far as that's concerned. Is that correct?
I can't speak exactly to the enforcement side on whether or not they send out a notification to DEA. Maybe Shannon or Reza would know about that specifically. On the DEA side, they do have a system set up that verifies licensure. And so at any point, if they saw something that went against our furnishing license here, they would reach out to us immediately, or act on their end if something needed to be stopped or revoked, because their license type is specifically attached to the individual state licensees for the practitioners that partner with them. So they have that managed on their end, and I can't speak to exactly what that is, but they do have a notification system there. On our end, I don't know, Shannon or Reza, do you know if we send out any specific notification to DEA, or do we rely on DEA validating the license types?
Their system, we don't send out specific notification. The only notification we send out is to California Healthcare Services and CDPH and Social Services for surrenders and revocations, because they have to be taken off the Medi-Cal Medicare list. They can't work anywhere where there's billing for that. Other than that, normally we are notified by DEA unless it is a criminal activity where we are taking action. They would have been referred over to the local district attorney's office for criminal prosecution. And at that time, I believe all parties are notified.
Mm-hmm. And then I guess my next question my next statement is more of a statement as it relates to the billing and the record keeping that Dr. Ray brought up. Currently, as nurse practitioners and as midwives, any procedure having informed consent, as well as billing procedures, we are held, from what I understand, in accordance to not only Medicare and whatever insurance billing recommendations and CMS, but also we are currently being monitored or held to the standard under 810A1 that's listed falsifying or fraudulent claim for payment or loss under contract of insurance. So my question would be, is there additional information that's actually needed at this point in time? Because as EO Melby already stated, we already have APRNs that are functioning independently, that are already functioning under this guise and this discipline already.
Can I comment on that?
Sure.
Yeah, I mean, I would argue that, the jurisdiction of the BRN is very different than Medicare and all these federal entities that may be having requirements that are overlapping. I think the mission of the BRN is to, make sure that practitioners are practicing safely and are, have the patient's best interest in mind. And sometimes there are situations where it's hard to elucidate what was not done correctly and when a complaint is filed. And I think this is a very powerful way for the BRN, the same way the medical board does, to discipline practitioners who are doing things that are deviating from the standard of practice, but it comes down to a he said, she said, and they really can't, say that somebody was unprofessional because they can't prove it. However, creating a requirement on the state level that medical documentation has to be followed in order to be within the standard of care is a powerful tool to enforce that. And medical boards use that all the time. And all I'm saying is if the BRN wants the power to say, look, you may not have broken any laws, there may not be any evidence that you committed any sort of gross crimes, but if a patient was harmed and they're claiming that you did not do something that you say you did and it's not documented, they can then use that as a tool to discipline that individual. And so this is not about saying that people are not doing their jobs and that there's no oversight. That's not what this is about. This is about like handling complaints and handling them appropriately in a way that they actually have some teeth so they can actually enforce them. Does that make sense? I mean, it's not
it
not
does,
trying to imply that there isn't already some standard of care being followed.
It makes sense that it's accountability administratively on the practitioner side to have appropriate documentation in order. So if what I'm understanding you correctly, so regardless of whether or not there was a violation of care, there's a violation administratively of them keeping the records that legally they have to keep based on regulation.
Well, exactly. And I know this sounds very petty, but very often in order to respond to a complaint, you need to kind of break it down to that sort of level and say, if everything had been done correctly and it was documented, then the practitioner would be safe and protected because they followed the appropriate procedures. Even if it's not a gross violation of professionalism. I think forgetting to document something in a chart is something we all do once in a while. But if it comes down to something that's like a major, life-changing event that there was absolutely no documentation of it occurring, then that's a violation of professionalism. And I think it needs to be in the code in a way that people can enforce that.
So Dr. Ray, I guess my question would be, where would that exactly? I completely agree. Let me just say that. I completely agree with that statement. However, how do you put that into a language?
So if you look at the documents that we received under, okay, well, there's the recommended guidelines for disciplinary orders and conditions of probation that we received as part of this meeting under the first section, which I think is on page 4. We talk about different types of under the Nursing Practice Act. I mean, obviously that comes out of statute, right? So we're not trying to necessarily add to the statute here. But somewhere in this portion of the document, if you can include examples of something that would constitute, violating professionalism, this would be a very specific example that perhaps up until now hasn't really had to be dealt with by the BRN because this isn't a very common issue. You're not necessarily. I mean, even you give the example of nurse anesthetists. Okay, yes, they operate without standardized procedures, but they also tend to operate within an infrastructure in a medical institution. They're in an operating room, they're administering anesthesia. The institution that they're working in has rules. But we have a 104 practitioner who's going to be out there in the world treating patients in a way that is very analogous to the way a lot of physicians treat patients. There's a little bit different standard there in terms of what can go wrong in that environment, and how do you address that?
So I have a question. So I think when it comes to disciplinary, I don't really think like in terms of like, I think you function in 103 or 104, like for example, like the consent form, right? The patient goes under surgery, consent forms are done. Like, so I work in an institution where the consent form is not sent, they don't sign it electronically, right? So they sign on a piece of paper and then it gets scanned in. So let's say, I do minor procedure. I don't do any procedure, but let's just say I do, like, let's say I did a cyst removal. But then now that consent form, which you did, goes to medical record to be scanned, goes missing. So it almost feels like, the nurse practitioners would have done their due diligence explaining, and they would have charted in their chart, but the actual consent form may be missing. You know what I'm saying? But it has nothing, I don't feel like the MP should be disciplined because she did everything she can. And then there's like a,
No, I think you're misunderstanding.
saying?
I think you're misunderstanding what I'm saying. So this is something that's done in the medical community all the time. This is not we're not just making up something here. So the medical documentation is the actual physical paper or computer record is something separate. When you're in a system and you're like working in an operating room and a patient's about to have surgery, there's a million different people who are looking at these things and checking off their checklist. So nobody's going to be like in trouble for saying, oh, you didn't get consent on that patient, because there's 5 different people who've seen that consent performed. But what I'm saying is there should be something under the list of potential violations that says that, there was basically very significant deviation from standard medical record keeping. And this actually happens a lot, unfortunately, out in the world. And that is a way to discipline a practitioner for sloppy practices, basically. This is not to say you're working in a hospital and somebody, accidentally deletes a note. That's not what this is about. This is like an entire medical record doesn't exist because a person is just performing procedures without getting consent. They're not documenting things. They're not explaining the procedure to the patient. I'm just giving one example, but I think there should be something like this similar to to the standards that we hold medical physicians to when it comes to professionalism and standards of care. And I'm really focusing more on the 104s because these are the people who are potentially going to be practicing independently. They have to set up an office. They have to be held to the same standards.
I'm having, because when it comes to discipline, I don't know how we would discipline a 103 versus a 104 differently. You know what I'm saying? Because when we write these standards, the standards should be equated throughout. We can't say a 104, you have to have that form, or you have to have, I mean, obviously, I totally agree. If you see a patient and there's no entry at all, that's a no-no, right? But when it comes to, let's say, maybe a couple MPs come together later on 3 years from now, and they form their own medical group and they are independent, right? Then what happens if like you had previously, like a consent form goes missing? So I think that becomes a great area. I don't think anybody would disagree if a whole visit is gone and it's not like a computer glitch or something happened, I think that's definitely
I wish we had a member of the medical board here to explain this better than I can, but this is a whole body of professionalism. This is a component of professionalism. When we judge medical residents, we're given a list of core competencies, and one of them is, record keeping. Is basically keeping accurate records. We judge them specifically on that because it's a legal document. And if people get sloppy about that and they're not paying attention to it, that's a serious violation of professionalism. It's not to say, you're not going to occasionally make a mistake. That's not what this is about. This is about a pattern, that emerges of a practitioner who is not following the standards of professionalism.
Yeah, that means we have to really define it, right? To create a pattern.
And I also think that this is much more than just a nurse practitioner thing. If I use an old term, not documented, not done.
Yeah.
That's pretty much what we're talking about. And I think that is already, that is clear, or to me, that is, I guess what you're wanting is a line within here somewhere speaking to the importance of business practices, documentation, and things that as it relates to 104 MPs specifically, but that relates to all MPs. And it's already, and I think that that's something that's already in existence in this body of work that we already have right here. Now, I think that if we want to talk about business practices as it relates to anything else. I mean, I don't know what else that could be, maybe insurance, liability insurance, any of those things. I think that those are things that we could discuss, but I think documentation is clearly something that the expert nurse practitioner would definitely say is something that would be outside of the bounds already. If you weren't doing it, that's unprofessional. And that is way outside of the bounds of what a
Excuse me 1 second, really quick. Hillary Reyes has been bumped off and she is not able to participate because she's muted. Can somebody admit her?
Thank you, Ruth. I was trying to find a time to.
Sorry, I just kind of
say that. No, I appreciate it. Yeah, I didn't want to interrupt.
Intense on this one topic. You were just kind of sitting here, but anyway.
Can the board moderator get her back elevated to the group?
Thanks, guys.
Thank you. And just for future guys, send me an email if that happens. I'm able to get messages to the board moderator without having to interrupt the conversation online.
Okay, I'm done now. I think my ultimate, where I was ending was not documented, not done. That applies for everyone, as from an RN to an NP, whatever level, CRNA, nurse midwife, and that would be by all definitions outside of the bounds of professionalism and what a rational provider would do.
A reason why the medical board includes such specific language in their disciplinary guidelines. And if a 104 is going to be practicing very similar to an independent physician, I guess I'm not sure why one body would have that kind of language and the other wouldn't. They've been doing this a lot longer. I'm not sure. Maybe there's some precedent. I'm not privy to that. But I'm just telling you, when you compare those documents, that's one of the areas where it's very different.
Yeah, and I'll actually jump in here really quick, do a time check. We do have 1 hour left of this meeting. Again, just real quick, Dr. Ray, I actually tend to align with you on this one with the independent practice part. We do not have anything specific to private practice. And this was kind of what I talked about earlier when we opened this up an hour ago, is although scope of practice hasn't changed necessarily, the supervision has. And so what we really do need to take a look at is that independent practice aspect that's not specifically identified in our disciplinary guidelines. And we do need something in there for when a practitioner does go on probation. We don't have a practice monitor or anything in this setup that would allow for supervision. One of the things that we could talk about right now, or just put in the back of your head to think about as we move through this, is one of the processes for probation is that an RN, including our advanced practice RNs, must work in that setting. So whether they're disciplined as a nurse midwife, they need to work as a nurse midwife for at minimum 20 hours a week for 6 months as part of their probation. That requires a workplace approval. That requires a level of supervision. Right now, that level of supervision is minimum, moderate, and maximum. Minimum supervision says that a person that is assigned to be their kind of work site monitor checks in twice a shift. Moderate supervision is that they are with them on site 4 hours of an 8-hour shift or 6 hours of a 12-hour shift. And maximum is that they are in the work setting with them at the entire time that they're in that setting. That's obviously not conducive to a 104 NP practicing. It would also not be conducive to a nurse midwife in their own independent practice either. And so we would be unable to carry out a maximum supervision unless the nurse midwife worked with another midwife in their practice and they co-owned it or did whatever. But think about this from a practice standpoint. You're a nurse midwife, you do home births. Are you going to call a second nurse midwife to come with you to attend to that home birth? Because if you're on probation, that is what you would have to do. You would have to have another nurse midwife with you while you attended that birth in that home setting or home office setting or whatever, unless of course you were doing your practice solely as part of a hospital setting. If you are seeing patients postpartum or prenatally, you would have to have another midwife with you as you saw that patient's postpartum or prenatally, antenatally, any of that, as part of your practice. That currently is not something that we can do with a more independent practice. We would have to have somebody that is at your level or above that would be able to be approved for that supervision. Right now, that has typically been done under standardized procedures. So I know that we're familiar with disciplinary guidelines. I know that updating disciplinary guidelines sounds daunting, and I know that our advanced practice RNs do not want any further limitations to their practice or increased discipline, and I understand that completely. But it is not wrong in this conversation to say that the board has not adequately addressed the independent practice of our APRNs. We have addressed it in ways, we haven't addressed it in totality. So please be open to the conversations and the insight that is being provided to us by our physician members. And we do need, as part of due diligence, to look at the physician's disciplinary guidelines. And we may have to adopt some of those guidelines to be able to allow for advanced practice RNs to continue to practice independently if they are on probation. Because the only other option would be to remove their ability to practice independently and require them to go back down to standardized procedures. And I guarantee you that is not what our APRNs would want, but that is the way that our supervision is set up right now. So
can I interject just really quickly? This is Hillary, because you bringing up a really valid challenge in how we're going to, measure whatever this supervision is, and if it's an independent practice. But I was just going to throw out this that for example, when we're being measured or evaluated, when we're joining for privileges in a new hospital, we have to be proctored for a certain number of cases, and so. Really, it's, in terms of vagueness, just to say, okay, you're going to be monitored over 24 hours a week for 6 months, in a practice that's a solo practice where maybe you're only doing 5 births a month as a midwife, for example, or seeing, 5 postpartum visits or whatever that is. I don't want to prolong, how long it would take to get through this sort of, are you safe, are you not safe? But it would it might, be more relevant if somebody said, okay, because let's say you do have to, during this probation period, hire somebody to go with you to do these cases because you don't work in a community where there is somebody. So maybe you have to make an agreement in some other busier facility, but maybe it's like, okay, we're, if you can do 5 births and, I don't know, putting out, 10 follow-up visits and everything goes well, then we're going to say that, under the review that everything is fine.
Yeah, and that would have to be built into the disciplinary guidelines because that is not what they're today. So as of right now, if you're a nurse midwife and you are put on probation through the legal system, we've got the complaint, we've done the investigation, it's gone to the court, and the court has given us this stipulation that says this nurse midwife will do this. And this nurse midwife now has all of these things that they have to comply with that has been set out by the court. As the BRN gets that, and we want you to work, you guys are on, and the nurse midwife or nurse practitioner is on probation for, minimum of 3 years. And so in that 3-year period, we do have a supervision requirement. It's in the court documents. We have to be able to do what the court tells us to do, and that is to establish this supervision requirement. So say I'm working for the board and I get the information from the nurse midwife that they want to go back to their normal workplace. I call the workplace and I say, hey, this is Loretta Melby. I'm the executive officer of the Board of Registered Nursing. I'm calling on behalf of Nurse Smith. She is employed with you, and I want to make sure that she can continue her employment with there. I have to go through this questionnaire and see if you guys are able to provide that level of supervision. I then ask a ton of questions, and they make the decision whether or not they approve the work site in collaboration with me calling and getting that done. And I could tell you they can't always do that. So I might get all the way through the work site approval and they're not able to meet the minimum supervision requirements or the maximum or moderate supervision requirements, whatever the supervision requirements are set up to be, they're not able to meet that. So at that point, they cannot approve that workplace approval. And that nurse midwife or nurse practitioner does not get to continue working in that area, and they are terminated. That is the only option for that employer because they can't meet the requirements that have been ordered by the court through this stipulation. So if we don't look at this right now, it's still a fairly non-issue when we're looking at our nurse practitioners because right now they're able to be a 103, and that 103 and the standardized procedure NP, they are required to be in group settings and under the supervision of a physician. So the nurse practitioners, this we can still accommodate with the minimum, moderate, and maximum supervision. When we get to the 104 in 3 years, we better have regulations inside this disciplinary guideline that allows us to do this because we will not be able to accommodate it right now. The NPs in their independent practice will not be able to practice independently in the way that it is set up right now because we do not have that built into here. The nurse anesthetist, it was absolutely correct that even though they have independent practice, they are usually associated with a healthcare organization. That healthcare organization, they're in the operating room with a physician or surgeon, etc. Whether it's outpatient, inpatient, whether they're working in a dental clinic, the dentist has the provider certification, they're working with a dentist, etc. So they are practicing independently, but still within a group setting for the majority of times. We do have to take that into consideration when we're looking at approving workplace as set out by the court order. With our nurse midwives, as you can tell, there's only like 1 or 2 that are disciplined a year, so we don't run into this issue much. But what we do run into is conflict of interest many, many times with our nurse midwives because there's only a few thousand in California, and going to get subject matter experts and people that will oversee them, etc., we run into that issue. So there are unique issues with each one of our advanced practice RNs in their independent practice that we have to be able to work together and come to some sort of recommendation. We did look at the med board. The med board does have a person that is assigned to the physician as a practice monitor when they are on any sort of discipline. And that may be the route that the BRN would need to go to and mirror that of the medical board's disciplinary guidelines so that we can allow our advanced practice RNs to continue to practice independently while they are on probation. And so those are the conversations. And I know that we have a lot of advanced practice RNs on here that do not want to see these guidelines changed or altered, and they think they are sufficient for where they are right now. And that is true in many, many, many aspects. So we wouldn't go through and redo every setting, but we do need to address the independent practice part. And we do need to better address the legal aspects of retaining medical records, of maintaining them, of ensuring that those are accessible. Because again, as you guys are very well aware in our Nurse Practice Act, we don't have any documentation guidelines. That's not handled through the Board of Registered Nursing. Our documentation guidelines go to other state agencies, other accrediting agencies, and not through the Board of Registered Nursing. And so those are things that we have to take into consideration. We do get complaints against Title 22, and we look at the Title 22 issues that come in through CDPH and see again if it's unprofessional conduct, which typically it is. And so we are able to discipline as unprofessional conduct when we're looking at violations of Title 22. And please be open to that. Please continue to have conversations around that, but do not discount that we do have to come to some kind of an agreement when looking at independent practice.
Melby.
Video off, sorry.
Thank you. E.O. Melby, I just wanted to say the conversation, at least from my aspect, was not to say that there wasn't any work to be done whatsoever. I do believe that there's a lot of work for the 103 MPs that need to be done. I wonder if there's any way that we can also look at other states that have independent practice, that have had independent practice. I don't know exactly if they have the same rules and regulations, but I think looking at other states that have already done this and kind of what their practices have been might be useful for us to adapt some of their practices as well to help us move forward under the guise of what their BRNs are doing as well.
Yeah, we absolutely can do that, but just as a just a note of understanding is there are no Board of Nursings that are identical in any way whatsoever. So we will not find anything that is identical to what we have, but there are several states that are similar to ours. And we do reference those frequently when we're looking at, considering changes and updates and such. So absolutely something we can do, and probably something that will be done independently within maybe setting subcommittees up at the next NMAC and NPAC advisory groups to kind of tackle these various things. But what we're going to try to manage is when we get those recommendations, as you guys are working with them, that we're able to come to some sort of agreement for all APRNs again, and not have something really specific for NPs or really specific for nurse midwives, because again, practice is practice, independent practice, record keeping, billing, insurance, all of that is independent practice for any of our practitioners. And we need to kind of look at that as a whole, unless there is something that comes up that is completely off the wall, that we haven't taken into consideration that is specific for a license type only. And then we would do a specific call out for that. And that's absolutely something that we have the ability to do. The one thing I do want to make sure that we can kind of have a discussion around today too is the movement of cases through the BRN. And I know that in some of our advisory committees, the idea was on first pass that all of these cases that are filed for a nurse midwife or a nurse practitioner would come in front of the nurse practitioner advisory committee or the nurse midwife advisory committee. And you guys voted to defer to the disciplinary guidelines at this point. And that seems to be working. And I think that that's the process that looks like, at least in all purposes to me, that it would be maintained as to not have any delays. And so I want to make sure that that is what we're coming to as an understanding here when you guys have had a chance to review this, that what was put into place is working, that the subject matter experts that we actually find and have on the BRN side, as well as the subject matter experts that are on the defense's side, are typically much more qualified even than our advisory committee members because of the specific employment requirements, the length and practice requirements, et cetera, that are put forth to be a subject matter expert. That is not a requirement that we have our advisory committees. And so I know that we've had some kind of back and forth on that. I want to make sure that after this presentation with Shannon, that you guys are more comfortable with the subject matter experts opining on every case. There is not a case that goes through BRN that doesn't have a subject matter expert that is of equal to the person that is being looked at for discipline. So again, it is a nurse midwife that evaluates a nurse midwife. It is a nurse practitioner that evaluates a nurse practitioner in those practice areas. So we would not have a women's health nurse practitioner evaluate a psychiatric mental health nurse practitioner if the area was that of a psychiatric mental health nurse practitioner. And so again, when you look up at the makeup of our advisory committees, we can't guarantee that diversity of the 8 categories here with the various practice locations, with people that are being 103s and 104s, et cetera. So those are kind of the topics I would love to kind of open up and wrap up in the next 40 minutes so that we can adjourn on time. It does look like we will not be making any specific action today, more just discussion, and that potentially the specific actions will be taken at the next scheduled advisory committee meetings where we establish some subcommittees to work on various aspects of the disciplinary guidelines. Does that sound like something we're leaning toward today? I know I haven't heard from everybody all day. There's been a couple people, including myself and Shannon, dominating the conversation, but I want to make sure I give time for people to have those questions and answers and discussions now.
If I could just make a quick comment, I wanted to reiterate what Chairwoman Gambles-Farr stated about understanding what other states are doing. I do feel that we've asked that question in a number of different arenas, also around sign-off and how do we perform sign-off for a Section 104 NP. And as opposed to reinventing the wheel every time, I do agree that it would be really helpful to try to understand best practices from how other states have implemented these, because it doesn't seem that we would need to reinvent the wheel, and it would be nice to be able to borrow from people who've done this for a while in a number of realms. So sorry, I know you want to move on, but I didn't want to miss her point that she made before.
I would like to say something. I'm not sure if we have a hand raise option here, so I don't know if that. So one of the things before, as a kind of a closing thing, a question in my head, Loretta, based on what you said, when we get to the point where we have nurse practitioners that are functioning independently and there is a need for a probationary process specific to that, is that, I'm looking at the notes, that is that a regulatory thing that we will address here, or is there any legislative aspect that'll need to happen?
I believe, as was pulled up in our disciplinary guidelines right here, is supervision. And this is a regulatory thing. And so what we can do is update this supervision section to include a practice monitor for our independent practitioners.
Got it. Thank you.
You're welcome.
This is Hillary. I'm just going to jump in. I think, Loretta, what I understood you to say, I think this is that I feel like there's this, I keep bringing this up, but I feel like there's this portion of the Midwife Independent, Practice Act that says that the committee, and this is referring to the NMAC committee, shall provide recommendations or guidance on care when the board is considering disciplinary action against a certified nurse midwife. And that's quoted from that statute, so from the law. So I guess my question is, how...
Are you frozen?
Is Hillary frozen or am I frozen?
I think she's frozen.
I think Hillary is, unfortunately. She was making a good point.
Yeah.
So I think one of the things that was kind of brought up here, and I do see your hand up real quick, was she was asking about the lines that are in both AB 890 and SB 1237, where the committee will have that input. As a committee, each one of you guys voted that your input would be through the disciplinary guidelines. And that is what was adopted previously. and that is this input right now that you guys are doing on these disciplinary guidelines to update those regulations. That is where you guys will have the input on every single nurse practitioner or nurse midwife that is part of this process. If you're looking for something separate from that, if she's able to get unfrozen and start to speak again, that'd be great. But Dr. Byrne?
Just in clarification, so what we're looking for, just make sure I'm echoing back to make sure I understand. This would be the same uniform disciplinary orders and guidelines for both NPs and CNMs, correct? Not separate.
Yeah, we are not looking for anything to be necessarily separate unless you guys are able to identify a specific call out. If there is something that is completely not in alignment, we could do a call out. But by reviewing the practice, by looking at different practice options and practice complaints, when you put those into perspective, they kind of go down to the most basic level of being similar or even identical. It's a gross negligence. It's a practice violation. It's some sort of issue that is substance use disorder, something like that. And so the baseline ends up being similar for both areas. And this, I know that people are kind of, I don't know if I just have it on my computer, but on the very bottom of your screen, there is a raise hand feature. I'm not sure if it's showing on my screen and not your guys's, or if it's on your guys's screen.
No.
My follow up, in relation to that, with that clarity, thank you. Again, these changes represent some pretty big changes in autonomy and then compliance with business and professions code, including corporate practice of medicine, which is not specific to physicians. And so there's a lot of very clean language with a lot of precedent behind it in the Medical Board of California's guidelines for disciplinary action. Those are up and publicly available. They actually provide very good clarity for some of the things discussed here. The need for accurate records, the prohibitions against falsified records or absent records, the compliance with corporate practice of medicine and self-referral. I don't think these had been that germane for CNMs or NPs or RNs in the past. And yet these are part of the business and professional code that I think we really got to make sure these are incorporated in so that people don't inadvertently violate these standards. It's new territory.
Yeah, there's a lot of
times. That was exactly the point I was trying to make. That was, we're not reinventing the wheel. This language is all here within the state of California, within the, the Department of Consumer Affairs. So I don't know that we need to go to other states. The language is there.
I know that we do have about 40, almost 50 people in attendance. I would love to open it up to public comment at this point, get some input from our stakeholders and see if that spurs any additional conversation. Any objections to that?
Nope.
Okay. Board moderator, will you please open up to public comment?
Public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Kathy Hughes would like to make a comment. 1 second, please.
The executive, can you hear me?
Yes, go ahead.
Sorry, it was telling me
to ask to be unmuted. The executive director of the Nurse Alliance of SEIU California. And I just had a quick question because I thought I heard E.O. Melby say that these disciplinary guidelines are being used in practice for the advanced practice nurses that are already practice independently, the nurse anesthetists and the nurse midwives. So what has the BRN seen regarding some problems or things in these guidelines that they've seen as problems using existing language as opposed to developing or updating the supervision needed during a probation period or something like that? Have those problems come up, and how did you address it if you didn't have new guideline language? Thanks.
Thank you, Kathy. And yeah, that's exactly what you heard. We have been using these for all of our APRNs ongoingly. The things to take into consideration is the data that Shannon provided early on is with our nurse midwives, there's like 2 that are put on any kind of discipline process a year. And so they're easy to kind of manage at that point because there's so few in number, and we're able to work with them on an individual basis, get job placements for them that may not be their original employment. That original employment might be actually the one that filed the complaint and potentially terminate them on that. So we are able to work with them, get them employed, and work through that process. But we weren't dealing with the numbers that the nurse practitioner brings, right? Our nurse midwives are under 1,400. Our nurse anesthetists are under 3,000. And so the numbers are very, very low. Now that we've added the nurse practitioners into this independent scope of practice, we've added in about 35,000 practitioners that we could potentially have to address when we're looking at our disciplinary guidelines. So that is why the new impetus is here to really have us address and have a very strong process in place for this. The other thing is, if you look back, I believe at our sunset records and stuff in years past, that they have recommended us updating our disciplinary guidelines. Our disciplinary guidelines are old and are in need of review. So that is a process we embarked on. A few years ago, COVID kind of derailed us a bit. And when we started to get back on target for that, we noticed that we needed to get NPAC and NMAC's consideration on here because they voted to utilize the disciplinary guidelines as their tool for input into the specific midwife and nurse practitioner cases. So we are waiting to get the NPAC and NMAC input into this, and we intend to update the guidelines to be in compliance with the legislative request through sunsets, as well as the legislative request through SB 1237 and AB 890. And then we will be able to move forward with the new practitioner load that can enter into independent practice.
Paris Malouf Burry would like to make a comment. 1 second, please.
Thing 1 is with regard to the corporate practice of medicine, which does not apply to certified nurse midwives. It's not part of our statute. So yes, it is part of the Department of Consumer Affairs, but it is not. It's not applicable to registered nurses. I don't believe that it applies to nurse practitioners, and it definitely does not apply to certified nurse midwives at this point in time. In fact, there's a lot of talk about getting rid of it altogether. My next point is that I strongly believe that with the way that the language was worded in SB 1237, the intention was that the Nurse Midwifery Advisory Committee members would weigh in on each individual disciplinary action, not solely on the process, but on each one. And I do believe that if there really are only about 2 per year, that this committee has the capacity to at least review each of those cases. I would like to ask the Nurse Midwifery Advisory Committee to reconsider and revote on that topic.
I don't know, Reza, if you wanted to chime in on that, but I'll chime in real quick on just the nursing corporation aspect of it. Article 3.5 of our Nurse Practice Act talks about nursing corporations. Nursing corporations are part of our Nurse Practice Act, and we are actually held in compliance with the Moscow Knox Professional Corporation Act. And so that is something that we do have to consider because we do have nursing corporations and the Moscow Knox Professional Corporation Act that we do have to consider as part of our Nurse Practice Act.
The corporate practice of medicine says that physicians can't be employed by hospitals. That doesn't apply to midwives.
But we do have nursing corporations that we do have to address that has to be part of our Nurse Practice Act.
Right. That's not the same thing as the corporate practice of medicine. That's separate.
The medicine prevents self-referrals, though. There are economic conflict of interest themes.
In both SB 1237 and AB 890, they did include updates to the sections to include nurse practitioners and nurse midwives where you cannot do self-referrals as well.
Totally. Yeah, absolutely, 100%. But one of the major issues of contention with the California Hospital Association on previous iterations of this bill were that they did not want the corporate practice of medicine bar to apply to nurse midwives and to prevent them from hiring us outright. That was not part of our statute. It still is not.
Yes, correct.
That was not applied. So when we say CPM, corporate practice of medicine, my understanding is that most of our stakeholders, including CHA, CMA, ACOG, CNMA, et cetera, interpret that to mean exactly that. Not Stark rules, not any of the laws that prevent us from referring to ourselves, but specifically that we can't be employed by a hospital.
Reza, board counsel. There were 2 points. One, the corporate practice of medicine. I didn't initially fully kind of understand what was being said about that, but I think there's different understandings of what's being referred to when referring to the corporate practice of medicine. In the medical side, there is a ban. On our side, for example, with the nurse practitioners, my understanding is when talking about the corporate practice of medicine, the idea is that entities such as a corporation are not privileged to practice medicine. On our side, for the NPs, for example, in AB 890, there was language stating an entity described in subparagraphs. I'm sorry, I should give you the reference. 2837.103B. An entity described in subparagraphs A to F, inclusive of paragraph 2 of subdivision A, shall not interfere with, control, or otherwise direct the professional judgment of a nurse practitioner functioning pursuant to this section, ... That's, to me, the corporate practice of medicine and in this case of nursing. That statement I just read is to say that an entity is not privileged to practice as a nurse practitioner and shall not interfere with the judgment of somebody who's actually licensed.
I'm not arguing what that statute language says, but that's not CPM. Corporate practice of medicine is a separate law that prohibits hospitals from hiring physicians and does not apply to nurse midwives.
Okay, so I don't see that that's in the midwives or the nurse practitioners, what you were describing either. I'm not sure who said it was. The piece that you said about the nurse midwifery advisory committee should consider every case. Again, I think, that's been discussed and it's.
I'd like for it to be rediscussed if possible. I'd like for the midwifery advisory committee to have an opportunity to decide if they'd like to vote again on that.
Okay, so today's discussion is about the disciplinary guidelines. I was trying to say that the current path of using the DGs is, I think, a reasonable and fair interpretation of what was in the statute. If the legislature had something else in mind, the way we've gone about it, I don't think is unreasonable. And if they wanted to be more specific, that's something they certainly can take up and be more.
NMAC voted to do it this way. So clearly it was left to NMAC to decide how to do it. And if it was left to NMAC to decide how to do it, NMAC can redecide. If you interpreted the statute previously to allow NMAC to decide whether or not to weigh in on each individual disciplinary case, that establishes a precedent that NMAC had that authority at one point in time, at least to decide moving forward. She asked that moving forward from here on out, that NMAC simply agree that that was what they were going to do and not discuss that further. I am asking that they do discuss that further, that they reevaluate that decision and reopen the vote, since it was within the purview of NMAC to discuss that at one point in time.
We can agree to disagree. I don't think I heard Lori direct the NMAC not to consider it. I think you're right. If the NMAC decided to do it this way, they can certainly decide to do it another way. But as I said, today's meeting is about the disciplinary guidelines. That's currently what the NMAC has voted to do. They can add it to a future agenda if they want to open it back up to going the other route of considering all the cases themselves. That's a separate discussion we have had and we can continue to have, but that's not today's discussion. I hope that makes sense.
And then also, Paris, I would like to clarify, we were talking about the disciplinary guidelines. When we took that motion in both NMAC and NPAC separately, we did not have time to have them opine on the disciplinary guidelines or make any individual suggestions or updates to it. So the vote was to adopt the disciplinary guidelines as is, while we got to the point to put the input into the disciplinary guidelines and move forward. It wasn't setting a precedent towards any other process there. This is public comment. We do have other people that need to jump in. And then just to be clear that if the committee and legal counsel and such do decide to add that to a future agenda, that we would then discuss it in an open forum at that point, but it is not part of this specific agenda, so we will have to move on.
Thank you.
You're welcome.
Jenna, did you have a comment? Your hand was raised.
Yeah, I don't know what was said about a vote, but I do recall how it came to be that NMAC decided to kind of punt our involvement in disciplinary actions to providing guidance on revisions of these guidelines. But my understanding at the time was that we were told that was the extent of what our role could permit. And so if there is a possibility of a more real-time review of cases during the investigation prior to findings, then I would love to request that be added to a future agenda. Thank you.
We can discuss that further. I just wanted to remind people that when we did kind of have those discussions, that Reza did share specifically timelines and delay of a case and the strict adherence to that is a judicial system, not a BRN system. So we will go ahead and continue those conversations and continue to explain the process and the use of the disciplinary guidelines as to not cause a delay to the proceedings. So again, we can add this to a future NPAC and NMAC agenda item if we want to discuss that particular process more in depth.
Thank you. Malik King would like to make a comment. 1 second, please.
Hello?
Yes, sir. Go ahead.
Excellent. Good afternoon. I just want to say thank you for all you guys for what you guys have done and continue to do for the greatest well-being for the most amount of people. My name is Malik King. I've been a licensed vocational nurse since 2003 when I was 19, and a California registered nurse since 2007 when I was 23. I too have experienced disciplinary action. I'm currently awaiting my authorization to test number so I can take the RN exam again. And with this new law from 103 to 104, I was just curious to know, are there any disciplinary actions being drafted for nurse practitioners getting into the dental field? Nurse practitioner, dentist, or dental nurse practitioner, I don't know how they're going to word it, but I was just curious to know if that's in the works or not, so I can transfer my medical school prerequisites into a nursing practitioner program potentially. Thank you so much.
I could address that a little bit. 2725 talks, our Business Professions Code 2725 talks about supervision requirements, and a nurse as well as a nurse practitioner, et cetera, can work. Nurse anesthetists do all the time, work underneath the supervision of a dentist in a dental office. It is appropriate and part of the supervisory allocations that are in our Business Professions Code. Hopefully that helps to answer your question.
Thank you. Sherry Gast would like to make a comment. 1 second, please. Sherry? I'll come back to Sherry.
Real quick, board moderator, she did type in the comment section. I'll read it really quick. It says, regarding out-of-state APRNs applying for licensure in California with appropriate documents, are they allowed to be a 103? They would have to apply to California and begin working in California under standardized procedures to be able to meet the transition to practice requirements. Those transition to practice requirements are that they are completing the transition to practice in California. If you're able to get her off mute later, we can have her come back to public comment. But if that was her public comment, we've answered it, board moderator.
Thank you. And then I was going to give LJ a chance, but it doesn't look like they're on anymore.
So the comment that LJ put in there says, do we have a specific number or range that constitutes overprescribing narcotics that warrants referral to DEA or the board? Does the overprescribing apply to one individual or multiple individuals? How does the overprescribing affect an NP working in an outpatient surgery? What happens when a standardized procedure oversteps the boundaries of the NP's initial training and certification? Do you think at this time it will be worthwhile for NPs to stick to the Nurse Practice Act in order to guide them in the practice, is what I'm sharing? The NP is always going to be utilizing the Nurse Practice Act to guide them in the practice. They have no practice other than that is what is defined in the Nurse Practice Act. So I hope that will always be considered. Training and certification lead to competency. Every nurse, every advanced practice RN, including nurse practitioners, are expected to work within their competency and their scope of practice. A standardized procedure must be created between a healthcare facility, an overseeing physician, and the nurse that is going to be utilizing the standardized procedure. It is not done independent of that. It is a agreement between the three. And so a standardized procedure should not overstep a competency or a scope of practice. And if it is, that's something that would need to be sent to the board. As for prescribing, we did mention a cures report that we do get. That is something that gets directly shared with our board as well as many other boards. That is not the only method of us getting reports. Healthcare facilities run their own reports and do comparative analysis on either their Pyxis or the Omnicell or their manual processes for checking in and out of narcotics and documentation on that. And we get reports off of those avenues as well.
Thank you. Did you want me to see if I could get Sherry to try?
You can try. She is still in the comments. She did say thank you, but she did say unmute was not working. So we'll give her one more attempt.
All right. Okay, sorry. Board EO, Melody, there are no other public requests for comments. Would you like to close this?
Yeah, go ahead and close that. Shannon, you've stopped sharing, just so you know, and I think that's okay. We do have about 10 more minutes left. Were there any discussions that came about from the public comment that you would like to have further conversations about? This is a good time to reopen that and wrap it up for 4 o'clock.
This is Mary Kay. I'd like to recommend that any agenda items be forwarded to me for the March meeting for NMAC.
We would actually ask for that not to be sent to Mary Kay, as to not violate any Bagley-Keene, but to be please sent to Macaulay Fusarins, your liaison, to gather any agenda items, and then we will have a discussion. We always pre-meet with the chair and the vice chair of each one of our advisory committees, and we go over any agenda items sent and any topics that could or should need to be added to the agenda. So please don't send directly to Mary Kay, but please use your liaison as to not violate any potential violations of Bagley-Keene.
I have a question. This is Dr. Espinosa. So from NPAC point of view, will we be meeting in small groups regarding any recommendations in terms of the disciplinary guidelines?
So what can be done for moving forward is when we meet with the chairs and vice chairs of each of the committees, if they choose that should be added to a future agenda, which I'm assuming it will be, there will be a breakdown of the disciplinary guidelines. There will be choosing of committees, subcommittees, very similar to what the Nurse Practitioner Advisory Committee did when working on the regulatory language for the transition to practice and the 103 and the 104. And so at that point, we would set an agenda for the individual committee. And then on that agenda, we would put appointment of subcommittees, so subcommittee members to work on specific processes, and then we would have them report out at each one of our committee meetings as well moving forward. I know that we only have 2 committees scheduled for NPAC and NMAC this year, and I know that this is something we do want to move on, so I would hope that we do get that as an agenda in this first upcoming meeting, and that we assign subgroups and that they get to work pretty quickly on those so that we can get those updates and move the disciplinary guidelines this year so that we have something ready to go as more and more people enter the realm of independent practice.
So when is the next NPAC meeting for discussion, or at least breaking up into groups?
NPAC and NMAC are, I believe their next meeting is scheduled for March. All of those meetings were set at the end of last year, Dr. Espinosa, and they should be on our website. They were voted on from you guys. And we'll send out reminders and all of that kind of stuff to you so you have those. But it looks like March 7th.
Okay, thank you.
You're welcome.
Look at potentially amending these guidelines. Is there any thought to providing some language about the review process leading up to the disciplinary action, or is that a separate out of purview topic?
Rez, I believe that would go to you just because of the legal ramifications on that one.
Was the question about having discipline cases go to the committees at the investigative stage? Is that what you were asking about, Jenna?
Basically, since the guidelines kind of start at the conclusion of the investigation, it looks like.
It's a little bit complicated for a somewhat technical legal reason I'll try to explain, and I'll try to kind of analogize it to like courts that you're used to. There's a provision in the Administrative Procedures Act which governs the whole formal hearing process, which says specifically, and let me pull it up in case anyone wants a citation, that the investigative, prosecutorial, and adjudicative functions need to be separated, need to be kept separate throughout the process. Those three areas. And that's Government Code 11425.10, subdivision A4. So those three functions are the investigative. Of course, that's what happens immediately after a complaint is received, as the investigation takes place by board staff and board investigators and Division of Investigation staff. The prosecutorial function is the second one, and that's conducted by the executive officer as the complainant in the case, who's kind of analogous to the prosecution in a criminal case, as well as the deputy attorney general who represents the complainant. They handle the prosecutorial function. The advocacy functions, of course, is the defense of the licensee. The adjudicative function is really what the board does, and that's to be kept separate from the other three. Adjudicative really just means kind of deciding the facts and the outcome. So the reason I'm bringing all of this up is the investigative stage is to be kept separate from the adjudicative stage. So the board doesn't have any involvement, the board proper doesn't have any involvement in the investigation of cases. They are purposely kept kind of walled off from any knowledge about an investigation that's taking place, so that ultimately when a case is brought forward to the board you can kind of consider to be in the position of like the judge and jury in a criminal case. The board is walled off from all of that. So ultimately when the case is brought forward to them and they decide, they're only deciding based on what was entered into the administrative record at hearing. So the testimony and the evidence. Any other extraneous evidence or things that didn't actually make it into evidence and things are excluded. The board is kept kind of walled off from everything else that takes place prior to the formal hearing to keep them objective and all that. So all of that is to say that it is complicated getting even these committees involved at the investigative stage. I can't say that I've necessarily ruled it out, but it's something that would need to be thought through thoroughly, because the committees, NMAC and NPAC, advise the board. So if anything, there's not a great analogy here in like criminal courts, but if anything, the committees are kind of aligned with the board in terms of their function, insofar as the adjudicative, investigative, prosecutorial, and advocacy functions. So the NMAC and NPAC, to the extent that they have any one of those functions, probably ought to be kind of tied into the adjudicative function, which is the board's function. So if that's the case, then you're to be kept separate from the investigation and the prosecution and all that.
Got it. So
as I said, it was
definitely
kind
not appropriate to discuss the investigation in this guidance document. We will have a future discussion about the NMAC role in this at a future meeting. I guess I'm just still, it just hasn't clicked in my mind how NMAC providing guidance on the disciplinary guidelines in the adjudication phase jives with the language, which is that we should provide recommendations or guidance on care when the board is considering disciplinary action against a certified nurse midwife, which sounds like a specific person and or earlier in the process, but I will get it eventually. And I think
I understand some of you are kind of have it in your mind that this means what it means. It means the NMAC will look at each individual case, and it's kind of hard to accept the other interpretation. But I think the other interpretation, at the very least, all I can say is it's not an unreasonable way of interpreting what's there in statute. It's not a stretch. I don't think anyone could say the BRN is blatantly just disregarding this mandate in statute. But yeah, getting the NMAC involved is a little bit tricky. If anything, it would be at the kind of later adjudicative stage, and they would see cases similar to how the board does. And I presume we will be having that discussion again, so I won't go in depth into the reasons why it kind of gets a little bit easier said than done. We'll talk about that later. But yeah, the disciplinary guidelines, I think you can think of it as it is the board's recommendation to itself on care, level of discipline, and other aspects, rehabilitation and things like that. The board at one time thought through, hypotheticals and all the scenarios it thought it needed to address, and it decided what the recommendations were going to be, and it put that into regulation. And so that is more or less, you can, in a sense, think of it as the board's recommendations to itself. So here, you, being these two committees, are being asked to provide recommendations to the board through those disciplinary guidelines to address kind of reoccurring, potentially reoccurring situations.
And each of those are done on an individual basis. So every complainant that comes in, it's reviewed on an individual basis. Sorry, it's been a very long day. It is 4:00. We will be wrapping up. Ruth, I do see your hand raised. And so with that, it does get that individual look. And then it goes down through the disciplinary guidelines and says, okay, where does it fit? Again, on an individual basis. And then it gets its own court proceeding, and it's looked at individually. So I hope that we're able to kind of explain that so that everybody feels like they've been heard. Everybody thinks that they are getting exactly what they are expecting out of this, and that we can meet the letter of the law. There is never a point that the BRN wants to violate any of the laws that govern us, right? And so that is not something that we would ever set out to do. So we will review those processes. We will meet with our chair and vice chairs of each one of the committees, and we will set future agendas. We do need to adjourn, but I do want to let Ruth make a final comment as her hand was raised. I think you're on mute, Ruth.
Yeah, so this is not going to be the dramatic wrap-up thing, but I just wanted to say with Shannon, with the one slide, and see, this is where I see where we could help. There's not a lot of us in the state, and when stuff happens bad with midwives, it usually is really bad, right? And the first comment on that slide was a water birth caused the shoulder dystocia. First of all, shoulder dystocias are not caused really by any one thing. I mean, I won't go into the clinical things, but I think that there could be a lens that the advisory committee, the Nurse Midwife Advisory Committee, could lend to. There were some things that looked pretty serious on that list, but number one, you know what I mean? I think we could help.
So Ruth, I just want to comment that those 5 items were the allegations. So that wasn't the finding. I just want to make a point that those were the initial allegations and not the findings after the investigation.
Yeah, and again, I don't know if
those allegations come in from lay people. They come in from people that are not practitioners. That's what's received by us. That does not mean that that's what the action was that was taken on that.
Well, and again, so I think we can lend some clarity to maybe what directions that would be good to push on in that case.
Absolutely. And then please just kind of remember in the back of your head as we have a break between about a month before we're coming back together as an advisory committee, that Shannon, can you reiterate it real quick? What is subject matter expert? What are the qualifications that a subject matter expert must have that does review every single case at the BRN?
So for advanced practice, they would need to be an RN for at least 10 years. They would need to be in that advanced practice for at least 5 years. They would need to be currently functioning in that advanced practice role. No discipline against their license, no previous criminal history, whether expunged or dismissed. And just to let you know, our experts, especially our midwives, I think one of them, her experience is 42 years as a midwife, and I think the least is just under 20 years. So that's the extent of the years for our midwives, and I'm assuming our nurse practitioners are probably very similar. So they have to have quite a bit of experience, and like Lori said earlier, it's got to be in the same exact arena. So an NP is not an NP across the board. It has to be an NP within that specific scope and arena that we are getting them to opine.
Okay. Barring no other comments, it is 4:04, and we can adjourn the joint Nurse Practitioner and Nurse Midwife Advisory Committee. Thank you guys all, and thank you, Shannon. You carried it. You did it. You need some tea or something, or hot water, or some lozenges for that 6-hour meeting that you talked the entire time. No, I'm joking. We knew you would. I love it. So thank you very much. And I'm also getting emails saying that your presentation at the beginning of the day should be moved to our board meeting as well. So we'll probably break it up into separate sections, not do 3 hours straight at a board meeting. So enjoy the rest of your day. We will adjourn at 4:05, and we'll see you guys in March. Thank you.
Thank you, everyone. Thank you.